Fifth leave, I may be permitted to move an urgent application in the post of chief engineer, the selection. The judicial order, which was passed pursuant to the submission of the government advocate, that my selection will be considered on merit, has not been done. And I have been downgraded. And today, during the course of the day, 2 officers will be promoted. As regards the first one, I won't have any one. The second one, complete dehouse the rule, they applied the OMOP. So I call for judicial intervention. So, and today, tomorrow is a holiday.
So 1st February, we'll pass orders. Let it come up on 1st February.
And today, if they
We'll take care of it. We'll take care of it.
on 1st of February.
Day after tomorrow. Yes.
May I please, my lord, I'd like to mention for admission, my lord, any day next week, my lord, suspension matter. Suspension matter, my lord, it's supposed to be listed after 4 weeks, it has not been. Any day next week.
May I please? I beg to mention this item for posting on 2nd, my lord. It's a small matter, my compensation for admission.
Lordship, this admission matter posted on last 6/5/2022. Any date may be.
No, but there are many such cases posted. What is the urgency?
Urgency, my lord, because it is a correction of date of birth. Is in yesterday.
You wait. You mentioned after 10 days.
No, I seek to mention a matter where I've sought imposition of a minor penalty against my client Miller. I'm requesting for posting on 8th of February. 8th of February.
For what?
No, it's for fresh. It's a fresh matter for admission. 8th of February. Great.
May I please, Lordship? What's your back to mention item number 58 of daily instruction? I am for the petition. So the standing counsel, Mr. Anganwadi, suffering from sleep disturbances. That's the matter will be taken after 2 weeks.
Item number?
58. After a week.
No, 1 week will not be possible. All adjournments will be for 2 weeks minimum. The learned counsel for the respondent raised for adjournment in this case on the ground that the arguing counsel is unwell. First up, Mr. S. Banik, learned counsel for the petitioner, is present and submits that the matter be posted again after 2 weeks. And submits that he has no objection to the prayer, that the matter be posted again after 2 weeks. Prayer allowed, register to list the matter accordingly.
In the meantime, extra copy will be provided.
Well, please, your lordship. With the consent of the other side, I take to mention item number 43 of the district.
Item number 43.
43, your lordship.
Yes, what do you want?
Lordship, we will be filing a affidavit in reply against affidavit in opposition filed by the respondent number 1 and 2. Lordship, may kindly adjourn for the day.
You are for the petitioner.
I'm for the petitioner, lordship.
Lordship, in this matter, kindly fix a date.
Date will fix in March. Either 2 weeks or March.
2 weeks. Lordship.
I laid it up 2 weeks.
Mr.
L. Sankam.
L. Sangam, learned counsel appearing for the petitioner, 2 weeks time to file rejoinder responding to the counter affidavit filed by the
Respondent
respondent
number 1 and 2.
1 and 2. Full stop. Prayer allowed. Let this matter be listed again after 2 weeks.
May I please, your lordship? I beg to mention item number 1. The matter may become after 1 week.
As paid for by petitioner's counsel, this matter stands adjourned for a week. Yes.
May I please, your lordship? Mention for unlisting my lord. So
Unlisted.
matter is very urgent, my lord.
What is the urgency?
Date of interview is fixed on 2 February, my lord. So after 2 February, it will be infectious, my lord.
1st February.
Deeply
Not today.
obliged.
Yes.
Lordship, I beg to mention item number 23. This matter may adjourn for today. And my senior advocate ANR.
On the prayer of learned counsel for the petitioner, this matter stands adjourned for 2 weeks.
My lord, in item number 3, I have filed an additional affidavit that may kindly be called for.
What is this matter?
My lord, the promotion matter, I have just bought the entire rule, my lord, the entire service rule, my lord, because only few extracts were annexed, but the entire rule would be required, my lord. So by only I have got on record.
So we'll have it on Friday along with the.
My lord, because the other side are also there, probably notice was not issued. Probably your lordship would be interested to issue notice, my lord, because on the last occasion,
No, we are not interested in anything. Interest is yours.
No, my lord, if your lordship goes for disposing it off at the motion stage, my lord, I have otherwise.
That is why I'm saying Friday we'll have the matter along with the affidavit.
Friday, I'm obliged, man.
You are appearing for whom?
For the pollution control. Board.
Pollution Control
Yes.
Board.
In
Some
fact-
promotion to
Yes, in
Chief
fact,
Engineer.
notice needs to go in this matter. Because we have to file a counter.
then you wait when the matter is called. up.
May I please, Your Lordship? Mention item number 35.
Hmm.
My lord, can it be taken up on 10th of February? My lord? 35.
My lord, I am for the petitioner, your lordship. Several times they have took time, your lordship.
All right,
to
we'll
file.
call up, be present when the matter is called up, then we'll see. Yes.
Yes.
Adjournment not granted. The matter will be called
Another,
up.
my lord,
Hmm.
I have a pending matter for admission, your lordship.
Go and give it to the register first. Request him.
Yeah,
Yes.
please, Your Honor, I beg to mention item 24. My senior is out of station. Kindly adjourn the matter for the Lordship.
You are for the petitioner.
Respondent.
Lordship, I am the petitioner.
No objection.
No objection, Lordship.
With the consent of learned counsel for the petitioner.
P.
Miss
Rava.
Huh?
P. Rava on
P.
behalf of
Rava.
AIIMS.
appearing on behalf of the learned CGC engaged in this case, raised for adjournment in this matter for 3 weeks on the ground of personal difficulty of our senior. Stuff. Since the prayer is not opposed, same stands allowed, list accordingly. Yes.
May I please, Your Lordship? Your Lordship, I beg to mention item number 45. Your Lordship, in this matter, Your Lordship, I was supposed to file the impediment application, Your Lordship. I may be allowed 1 week time, Your Lordship.
On the prayer of Mr.
I.H. Lashkar.
I.H. Lashkar, learned counsel for the petitioner, 2 weeks further time is granted for filing the application for impediment by following the due process of law. Let the matter be listed accordingly. Yes.
Obliged, Your Lordship.
May it please your lordship. First, I beg to list one WPC of 2022 for admission on 10th of February.
You first go and request the register.
Online.
May I please, Your Lordship? Lordship, I beg to mention for listing of a method orders column, madam.
Register.
Obliged, madam.
May I please, your lordship? Lordship, I beg to mention item number 2 of daily list motion matter. This matter will argue my senior, but he's one of relative died yesterday. So he's not present today. Kindly may adjourn for today.
As paid for by petitioner's counsel, this matter still passed over for the day. Yes.
Obliged.
Daily list, item 3.
We'll issue notice at this stage, that's all. But Mr. M. Viswas, learned counsel for the petitioner. The matter pertains to challenge made by the petitioner to the promotion of the respondent number 5 in the post of additional chief engineer.
Additional chief environment.
Additional chief environment engineer in the pollution control board, Assam. Full stop. After going through the amendments made in the petition, this court is of the opinion that the controversy cannot be resolved unless the respondents file their respective affidavits. Full stop. In view of the above, issue notice of motion returnable in 4 weeks. Since Mr. S. Borua, learned SCPCB. Who is for 1? Respondent number 1.
Is the forest department.
Mr. D. Gogoi, learned SC Forest Department, Assam has accepted notice for respondent number 1. Mr. S. Borua, learned SC PCB for respondent numbers
2, 3, 4.
2, 3, and 4. And Mr.
A. Dhanuka.
A.
A. Dhanuka on behalf of Mr. Anganwadi.
You have filed a caveat.
Yes, sir.
Huh?
Lordship.
Up to 4, no formal notice is required to be sent to the said respondent. Extra copies of the read petition be furnished to the learned departmental counsel. Mr. A. Dhanuka, learned counsel, has appeared on behalf of respondent number 5 on the strength of a caveat. The caveat shall be heard. In view of the above, service of notice is deemed to be complete in this case. Let this matter be listed again for admission after 4 weeks. In the meantime, affidavits, if any, be brought on record by the respondents. Promotion given to the respondent number 5 shall be subject to further order that will be passed in this proceeding. Registry to tag the affidavit dated
Today.
as it did above, filed by the additional affidavit dated so and so, filed by the petitioner with the record of this case.
And declare.
Additional affidavit filed by the petitioner today.
May I please lordship, in this matter also petitioner is expecting promotion lordship. He is the senior most junior assistant. And he is seeking promotion to the post of senior assistant lordship. He's as page
We
25.
issue notice at this stage.
Great, my lord.
Mr. S. D. Bukaswamy and counsel for the petitioner. The petitioner is agreed by petitioner wherein is serving in the post of junior assistant under the under
Joint Director
in
Health Service.
the establishment of Joint Director of Health Services, Gwalpara, post of agreed by non-consideration of his case for promotion to the next higher rank, that is the rank of senior assistant oblique upper divisional assistant. The petitioner has approached this court by filing the instant writ petition seeking a writ of mandamus. Mr. D.P. Bora, learned counsel appearing for the
Health Department.
learned standing counsel, health department pays for some time to obtain instruction in the matter. NOM 6 weeks. Since you have all,
Yes, my lord. All
since
done.
Mr. Bora has appeared and accepted notice to all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned department of counsel so as to enable him to obtain instruction and file affidavit. It is made clear that pendency of this writ petition shall not be a bar for the authorities to consider the case of the petitioner in accordance with law, if so advised.
Obliging.
Item 5.
In this matter, well, I prefer some time, some instruction of short form. As regards the fate of the application of the petitioner, madam, he seeks compassion appointment.
So we'll issue notice and then dispose it over at admission stage. What do you say?
Lordship can dispose of it, Lordship directing them to.
We will not. In motion stage, no. It doesn't happen
In
like
that
that.
case, my lord.
All right, heard Mr. J. Kalita, learned counsel for the petitioner. Peruse the amendments made in the writ petition. Stop. Petitioner is agreed by non-consideration of his case for appointment on compassionate ground. Full stop. 1995 application submitted. Today you want a direction.
Yes.
You are lucky that disposal will be dismissal. You want that order?
Lordship, problem is that all the applications Lordship were kept pending, Lordship, since last year.
No, nothing.
Now this may be issue, Lordship.
So for agree, sir. Full stop. It appears that the father of the petitioner died in harness on 13/8/1995, whereafter an application was submitted on 5/10/1995 before the DFO Karimganj seeking appointment on compassionate ground. Full stop. According to the petitioner's counsel, although the department has considered the application of similarly situated candidates after great delay, no such consideration has been bestowed upon the petitioner's application. Stop. Hence this petition. Full stop. Mr. D. Gogoi, learned standing counsel, Forest Department, Assam, as well as Mr. A. Chakravarti, learned government advocate, Assam, pray for some time to obtain instruction in the matter. Stop. NOM 6 weeks. Since Mr. Gogoi has appeared and accepted notice for respond numbers 1, 3, 4, and 5, and Mr. Chakravarti for respond number 2, service of notice is deemed to be complete in this case. Extra copies will be furnished to the learned department of counsel so as to enable them to obtain instruction, facilitating disposal of the writ petition at the stage of admission.
Item 6.
May please your lordship. Lord, person today advertised dated me Lord 18/5/2022. Lord. I had applied for the post of Gambura, Lord. Thereafter, my Lord, provisional select list was prepared, Lord. My name was there, Lord. But till today, Lord, I don't know whether my candidature has been rejected or my Lord, I am going to appoint, Lord. That is why I filed a representation before the authority, Lord. But till then, Lord, no, nothing has happened, Lord.
No, but have they published the final list?
Finally, similarly situated person has already been Lord appointed.
No, Gavra, which Gav?
This is Milord Joyantipur Revenue Village, Milord.
So have they published any list for that?
No, Milord.
Then why have you come? They will do it whenever at the right time.
Milord,
There is no duty to inform you what has happened.
No, Milord, Bhai said advertisement, Milord, same select list, Milord.
All right. Heard Mr. T.K. Bhuyan and counsel for the petitioner, peruse the amendments made in the writ petition. The petitioner is aggrieved by aggrieved by the fact that although he had participated in the selection process for appointment of Gabura in respect of Jayantipur village under Patharighat Revenue Circle of Durham district, and his name was included in the provisional select list, yet no final list has been published till today, and the respondents have also not disclosed any reason for not doing so. Under the circumstances, the petitioner has approached this court by filing the instant writ petition. Issue notice of motion returnable in 6 weeks. Since Mr. S. Dr. Standing Council Revenue and Disaster Management Department, Assam, has appeared and accepted notice for respond numbers
1, 2, and 3.
1, 2, and 3, and Mr.
CS Hazarika.
C.S. Hazarika, learned government advocate Assam, has appeared for respond numbers 4 and 5. No formal notice is required to be sent in this case. Extra copies of the writ petition will be furnished to the learned departmental council to so as to enable them to obtain instruction.
What is the name of the GMA be reflected?
Let this matter be listed again by reflecting the name of learned counsel for the respondents in the cause list.
May I pray, Milord, pendency of the my lord.
These are matters to be dismissed.
My lord, my lord, my lord,
So we'll dismiss it in admission stage.
my lord.
7 and 8.
These are the matters where the petitioner was suffering from mental illness, and at that point of time, an expert proceeding was held against him.
Tell us first, what is it?
As per Lordship's direction, I have received a single lordship. The single reflect that lordship when the disciplinary proceeding was inquiry officer lordship issued so-called notice lordship. At that point of time, he was not in the medical leave lordship. He's in the OSL lordship, overstay leave lordship. Initially, he was granted 20 days medical leave for treatment of his father lordship and for appearing the court case which is pending in the Ranchi lordship. And he was directed to lordship that leave period was 14/4/2021 to 3/5/2021 lordship. And after that lordship, the IO was sent a notice lordship. At that point of time, he was not medical leave lordship. Again, if there is no receive any information regarding this, he is not given any response lordship. And again, second so-called notice was issued lordship. Then her wife has lordship written a mail to the authority that lordship he is in the medical treatment lordship. Then lordship our inquiry officer has sent again a letter lordship requesting to provide the medical documents. Then he has sent the medical documents lordship. It is reflected that he is not an indoor patient, he is an outdoor patient lordship. Even last medical receipt, medical lordship prescription also shows that lordship is not required any rest lordship and nothing was advised lordship. It is the case lordship. It is not a case that lordship. We have started the DP when he was in medical leave lordship. My lord may issue notice at this stage, we will come with a detailed affidavit lordship.
If I will just take lordship care of 44 of the report. Page 44, maybe.
Just 1 minute.
Would the inquiry
So just inquiry report has been submitted.
and I have given my reply to it,
All right.
praying that I may be allowed to participate in an inquiry by cross-examining the witnesses and putting up my defense. There is no further.
Charge has been found to be proved.
Lordship. They have found the charge proved.
So, all right, you don't take any disciplinary action on the inquiry report till the next date.
Lordship.
All
We will
right.
file affidavit in the meantime lordship.
All right. Lekhak heard Mr. R. Majumdar, learned counsel for the petitioner. Aggrieved by the ex parte inquiry report dated 6/6/2022. The petitioner has approached this court by filing the instant writ petition. Inter alia contending that the inquiry report was submitting that the inquiry itself was conducted behind the back of the petitioner, without giving him proper opportunity to defend his case. That too at a time when he was undergoing medical treatment. Full stop. On the basis of order dated 23/1/2023, Mr. K. Gogoi Lanet CGC has obtained written instruction and placed the same before this court. So the court to submit that the inquiry was commenced at a stage when the petitioner was very much in service, and even subsequently, the petitioner was never admitted in the hospital, but was merely an outdoor patient. Under the circumstances, it cannot be said that the interest of the petitioner has suffered prejudice. First up, Mr. Gogoi, however, prays for 4 weeks' time to bring those facts on record by filing an affidavit. First up, in view of the above, issue notice of motion returnable in 6 weeks. Since Mr. Gogoi has appeared and accepted notice on behalf of all the respondents, no formal notice is required to be sent in this case. Extra copies of the writ petition be furnished to the learned departmental counsel, enabling him to obtain instruction and file affidavit. Heard on the prayer of interim relief, having regard to the facts and circumstances of the case, it is hereby provided that no disciplinary action shall be, no penalty shall be imposed upon the petitioner based on the inquiry report dated 6/6/2022 till the returnable date. The date of the report is same in the other matter.
28/4/2022.
He took us at 28/4/2022. That is the only difference.
Others will remain the same.
Next matter to inquiry report dated 28/4/2022. Baki everything will be same. List along with item 7. It would give a list along with.
I will like keep the signal as a part of the record. Now.
Sorry,
Keep the signal as a part of the record.
which one? The copy of the written instruction be retained. The written instruction bracket signal SIGNL be retained in the record.
Please, Your Lordship. I am aggrieved by the decision of the selection board, my lord, to adopt the seal cover procedure in my case, my lord, despite my name having been recommended for promotion from executive engineer to superintending engineer. A decision was taken, my lord, to adopt the seal cover procedure. My lord, on the face of it, my lord, this decision was wrong, my lord, because on the date when this decision was taken to adopt the seal cover procedure, there was no inquiry pending against me. Show cause notice is in fact issued by the department, PWD, my lord, 6 months, more than 6 months later on 6th of April, whereas the decision was taken to adopt the seal cover procedure on 28th September 2021, my lord. And this is squarely in violation, my lord, of the judgment of this honorable of Honorable Supreme Court, my lord, which upheld the decision of this honorable court, my lord, in Union of India versus Anil Sarkar, which also I have filed, my lord, along with my writ petition. So therefore, today what I am respectfully submitting is the petitioner is due for retirement in November, my lord. So at least my case should be considered, my lord. My lord will have to hear the other side, and I bow down to that, my lord. But at least, my lord, on the face of it, when a decision is prima facie wrong, my lord, and I have only a few months left for retirement, at least my case should be considered by them. And note, I had made a representation which was rejected on 12th of December 22, my lord. And there they are saying that an inquiry was pending when the decision, when the DPC had met, which is on the face of it wrong, my lord.
So at this stage, let us issue notice and then we'll see.
At least ask them to consider, because it just left with a few months.
Expertise.
Well, I'm saying, my lord, on the face of it.
No,
my lord.
but then we can't say that whether any DP was pending or not. Those observations we can't make.
My lord,
That is your submission. We have to give them a chance to rebut it.
my lord, then at least a short date I'm praying for, my lord, because of the few months left in his career.
My lord, he is retiring in November, seems, my lord. Yes. 3 weeks, my lord, 3 weeks time.
No, but was there any proceeding pending against him on the date of the?
That also I have to, my lord, instruction, my lord.
Well, the show cause notice is at page 48, my lord.
It's coming for the
Show
first
cause
time. my lord.
notice that was issued on 6th of April 22.
All right, Mr. Fukan, have some patience.
I got it, I got it.
Being impatient is not, and that too, your client has come at a very belated stage.
That was because the
Whatever be the
representation was
reason.
pending.
You can't come late and say that I am in a hurry.
I bow down, my lord.
That is not
May I
permissible.
request a
Yes.
specific date? my
Yes,
lord?
yes, heard Mr. A. Pukan, learned counsel for the petitioner. The petitioner is aggrieved by the decision of the authorities to keep his case in a sealed cover. Keep the consideration of his candidature for promotion to the post of superintendent engineer bracket C bracket close in a seal cover by contending that on the date on which the DPC had made the recommendation, that is on 20th/9/2021,
Yes, my lord.
there was no pending proceeding against the petitioner.
Pending disciplinary proceedings.
Pending
initiated by the
disciplinary
PWD.
proceeding against the petitioner. And to such extent, the impugned decision is violative of the rights, is not only violative of the right of the petitioner, but also the law laid down by the Supreme Court in the case of
Union of India versus. Anil
Union of
Sarkar.
India versus Anil Sarkar. Bracket citation.
My lord, it's not reported, though it's a reportable judgment. I have cited it, my lord. It's at page, annexed it at page 65 of the writ petition, my lord. It's civil appeal number 2537 of 2013.
Third bracket of divorce civil appeal number 2537 of 2013. Bracket close. Mr. R. Dhar, learned standing counsel PWD Assam, has appeared for the respondents and submits that 3 weeks time be granted to obtain instruction. Similarly, this stand of Mr. C. Hazarika, learned government advocate Assam, appearing for the official respondents. First of all, responding to the above, Mr. Pukan submits that his client is due for retirement on attaining the age of superannuation in the month of November 2023, and therefore there is urgency in the matter. First of all, after considering the submission made by learned counsel for the parties, this court is of the opinion that the matter calls for expeditious disposal. First of, however, without giving an opportunity to the learned departmental counsel to respond to the allegations, the writ petition cannot be disposed of. First of, as such, issue notice of motion returnable on 27/2/2023.
My lord, may I request for 1st of March, my lord? I think I'm from
1st of
Delhi.
March, 1/3/2023. Since Mr. R. Dhar has appeared and accepted notice on behalf of respond numbers
1 and 2.
huh?
1 and 2, madam.
1 and 2. Why not 4? PWD, chief engineer.
My lord, here in my petition, full
Personal department. There is a discrepancy between my learned friend's petition and my petition. For some reason, there is.
I'll check that, my lord, because there was another. writ petition
here,
filed.
4 is the personal department.
My lord, in this matter, my lord, 4 is the Department of Housing and Urban Affairs, and the 3 is a Department of Housing and Urban
Mr.
Affairs.
Pukan, we are so sorry. We'll have to take it up on first or any other day. You have to correct it.
I'll certainly correct it, my lord. I think.
No, you first correct it.
My lord, we have actually.
You
filed
first
two-
corrected. This court cannot pass an order on an assumption.
No,
Who
my
is,
lord, actually 2 writ petitions were filed. They are, I think, taking up the other writ petition, my lord.
which is the writ petition?
There's another writ petition which I mentioned today, my lord, in the morning, my lord. This pertains to the penalty which is imposed on me. That is challenged, my lord, by way of another writ petition. I think they are considering looking at that writ petition.
You sort it out. We'll take it out
I'll
after
sort
5
it out.
minutes. 5 minutes.
I'll-
Write it out the order.
Item 10.
May I please? Apprehending termination, my lord, I have come before your lordship. That my service has been treated as a co-terminus, orderly PM. Page 43. It was in respect to the clarification. I was appointed regularly, my lord. The clarification, an objection was sought, made by the treasury officer regarding.
Have the conference outside, please. Your appointment as a what? Peon,
Orderly PM.
orderly peon.
Orderly PM, there is no clause as such.
So post was advertised.
Post was advertised.
When, what is the date of advertisement?
Advertisement I have not enclosed, my lord.
But do you know the date?
No, my lord, it was, he got the message in the notice board.
Then how many candidates were there?
I think that this also not there. In
Without
fact,
that,
he is a physically handicapped candidate and ST. So considering that aspect of the matter, he was appointed. And his appointment.
we issue notice at this stage. I heard Mr. S. Sharma, like counsel to the petitioner, peruse the averments made in the petition, apprehending a termination order. Apprehending an order terminating his services in near future, the petitioner has approached this court by filing the instant writ petition seeking an order of protection. Mr. A. Chakravarti, learned government advocate Assam, and Mr. R. Ahmed, learned counsel for the
I'm a,
4 and 5.
I'm appearing for respondent one, Lordship.
A. Chakravarti of 1 and Mr. R. Ahmed for 4 and 5 have prayed for some time. Only for 4. Have prayed for some time to obtain instruction in the matter. NOM 6 weeks. Since Mr. Chakravarti has appeared and accepted notice for respondent number 1 and
FD.
Mr. Ahmed for respondent number 4, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the learned. Mr. Sharma, these writ petitions are not maintainable.
I have, in fact, I have included.
Only thing we can say is we'll have to dismiss it at the admission stage. That's all. You have no case whatsoever.
Only consideration of it because.
No, there cannot be an order saying that don't terminate him. That order this court cannot pass. That will be a wrong order.
Only page 61 you will find the interim order passed earlier cases. It was not a
No, this kind of orders cannot be. You don't even know how he was selected.
No.
That also you don't know.
I was called for.
Called for by what?
Called for by respondent number 2.
Of course, you will be called for. Otherwise, the respondent number 2 has to come to your house. You will be called only. But when was the post advertised? What are the rules? What is the selection?
In fact, there is no rule as such.
All right, the petitioner to take steps for service of notice upon the remaining respondent by register posted.
Some protection.
Eh?
Some protection.
No. And this will backfire because of this proceeding now. There will be problem.
Item 11.
These are actually court of minutes posts. You check up the earlier judgments of the court. Those days are gone. Those days are gone when some orders, now it is not possible. It is creating problem for the system. His service will be terminated and you can't help it. You can't help it. Once we give it to him, another 500 will come. It cannot be done. I'm so sorry.
All right. Regarding the promotion of the petitioner. In this case, petitioner appointed as peon lordship in the year 1990.
Only notice at this stage. Mr.
Lordship.
Mr. B. Malakar, learned counsel for the petition. Parents, the averments made in the writ petition. Issue notice returnable in 6 weeks. Since Mr. S. Sharma, you are appearing as
All the respondents, additional senior government.
additional senior government advocate Assam has appeared and accepted notice for all the respondents. No formal notice, extra copies.
A date may be fixed.
Date will be in the month of April. Choose a date.
Petition is going to retire on March.
Yes, yes. But he has come after how many days, how many years?
Earlier, lordship, he come lordship, the court passed out on lordship.
Item 12.
The petitioners before your lordship, my lord, a senior personal assistant of this court, my lord, they were asking for pay scales and the other benefits under 7-pay commission. And similarly situated some other employees that is called computer assistants. And this person, senior personal assistants, they were pursuing the matter by the registry with the government. Of late, my lord, the computer assistance case has been allowed by the government, and lordship can see the order at page 71. But the senior personal assistants are left out. That is why they are before your lordship, my lord. And the computer
Senior personal assistants are working in the High Court.
Yes.
Registry.
Yes. And my lord, the similar matter, my lord, which was instituted by the computer assistants, being WPC number 4464.
Alleging anomaly in fixation of pay for the senior personal assistants. under the Assam Service bracket revision of pay bracket close rules 2017, the petitioners who are serving as personal assistants in the registry of this court has approached this court by filing this writ petition inter alia contending that while such benefit has been granted in case of copyist computer assistant, the petitioners have been left out without any valid reason. Hence, this writ petition. First, I've heard Mr. S. Chamal and counsel for the petitioner. Issue notice returnable in 6 weeks. Mr. H. Chakravarti, learned government advocate Assam, has appeared
Judicial Department.
on behalf of the respondent number. High Court is not represented, is it?
High Court, standing counsel's names are sworn. My lord. Should be sure.
My lord, I'll take, Mr. Das will take notice.
Who is the standing counsel finance?
Finance, Mr. B. Gogoi, my lord. I'll inform you, Mr. B.
Mr. B.
Gogoi.
Gogoi, learned SC Finance Department, Assam, has appeared and accepted notice on behalf of respondent number 1. Mr. S. Sharma, learned additional senior government advocate Assam for respondent number 2, and Mr. U.K. Nair, learned senior counsel assisted by Mr. H.K. Das, has appeared for respondent numbers 3 and 4.
Copy.
As such, the respondents are represented in this case. Issue notice is 6 weeks. Petitioner to furnish copies of the petition to the learned Department of Counsel so as to enable them to obtain instruction and file affidavit responding to the allegations made in the petition.
Similar matter, my lord, WBC number 4464 of 2022.
On the request of Mr. Sharma, let this
Be tagged up in this.
let this matter be listed along with WPC number
4464 2022.
4464 of
2022. Oblet.
Item 30.
May I please, madam? My lord, this is with regard to a recruitment exercise which was made in AIIMS. My lord, for the post of associate professor and assistant professor, microbiology. Now, my lord, the manner in which the selection was held, all the posts that were advertised, there was a single selection. I applied both for associate professor as well as assistant professor. My lord, there was a single selection, but my lord, in the other vacancies, say, my lord, a person who got the highest mark in associate professor, he was given the post of associate professor. The waitlisted candidate was appointed as assistant professor. Now, in my case, my lord, there are 2 markings. One for the post of associate professor, wherein I have scored high. I was the waitlisted candidate. And the other 2 candidates, other candidate who has been now appointed in the post of assistant professor, she was waitlisted number 2. But my lord, for the post of assistant professor, they have shown that I have scored lower marks. But there was only one selection process. If my lord can come, they have been appointed now, my lord, at this stage, because they are working in the organization now. My lord only can come to page 96.
But is your petition not dead?
No, my lord. It
may not be buried, but is it not dead?
It's not dead because I got this information only in November 22, my lord. He was in Delhi, he's working in Safdarjung Hospital, my lord. He's agreeable to get a post of assistant professor. He's an associate professor there, only because of family reasons, my lord. Page 96, my lord. My lord would find the recommendation of the standing, this is for associate professor, the first one. Deep Jyoti Kolita, I have no grievance, my lord. Next is my name. Vikramjit Datta, waitlisted number 1. Kaushalya Raghuram, waitlisted number 2. Now, my lord would see in the next column, assistant professor, Kaushalya has been shown to be selected. Whereas, my lord, my name figures nowhere. The marking, my lord, is at page 97. Same selection, my lord, only one selection. Vikramjit Datta petitioner got 67.3 marks for associate professor.
Whereas, my lord, for assistant professor only 63.1. Whereas Kaushalya Raghuraman, my lord, who was waitlisted candidate number 2, 66.8, and in the assistant professor 68.2. Now, my lord, interesting thing, the next two replies. Why Dr. Vikramjit Singh Datta was considered for the post of associate professor only? The information regarding this is not available in the minutes of the meeting. Reason for not selecting the waitlisted candidate number 1 and instead selecting candidates at lower serial number, the information regarding this is also not available in the meeting. So, my lord, if there was one selection, how can there be two marking? This is my grievance.
Yes,
My lord,
who has conducted the selection?
it was by the AIIMS authorities. So notices will have to be.
I'm for number 1.
All right, heard Mr. UK now, Land Senior Counsel assisted by Miss
You, Sharma, my lord.
U. Sharma, and counsel for the petition.
You, Sharma.
The lead petitioner herein had submitted his candidature for 2 posts, namely assistant professor and associate professor in the All India Institute of Medical Science (AIIMS) to be established at Guwahati, Assam. According to Mr. Nair, there was one selection process for both the posts, whereafter marks were awarded to the candidates. Notwithstanding the same, and despite the fact that the petitioner had scored higher marks, the respondents have not selected him. It is also the contention of Mr. Nair that in response to the query made by the petitioner, the authorities could not furnish any reason for not doing so. As a result of which, this is a clear case of discrimination. Discrimination against the petitioner. The learned senior counsel for the petitioner therefore prays for issuance of a writ of certiorari, setting aside the appointment of the private respondents.
Number 5 and 6.
Numbers 5 and 6, and for issuance of a direction to appoint the petitioner pursuant to the aforesaid selection process. Stop. Ms. R. Devi, learned Central Government Standing Council (C), appearing for the respondent number 1, prays for some time to obtain instruction in the matter. Prayer allowed, issue notice of motion returnable in 4 weeks. Since Ms. R. Devi has accepted notice for respondent number 1, no formal notice is required to be sent to the said respondent. Extra copies of the writ petition be furnished to the learned CDC, requisite in numbers, so as to enable her to obtain instruction. Petitioner to take steps for service of notice upon respondent numbers 2 to 6 by registered post with AD within 3 days from today.
Lordship. And my lord will also give me a liberty to take Dasti, my lord.
Dusty on whom?
On all these respondents, AIIMS and the private respondents.
In addition, the petitioner is also permitted to serve dusty notice on respondent numbers 2 to 6 to be routed to the registry of this.
Lordship.
Item 14.
Anganwadi worker.
Yes, my lord. The petitioner was initially appointed as Anganwadi helper, my lord. Thereafter, my lord, she was appointed on, my lord, in 2013. She was appointed as Anganwadi worker pursuant to selection process. But, my lord, due to my lord, wrong understanding of the government that in many Anganwadi centers for promotion cannot be made, they were appointed as on in-charge basis. The approach honorable court, my lord, which directed the authority, my lord, to consider the case. Now they have, my lord, without holding any selection, the private respondent has been selected by the union selection, my lord, order. First, we'll find the
Selected for what?
for promotion to the post of, my lord, Anganwadi worker, against which the petitioner is working since 2013.
So your client, she is still working.
Still working, my lord.
What is the problem?
My lord, now they are going to appoint the private respondent, my lord, as Anganwadi worker of that center, my lord, whoever the petitioner is working.
So what is the problem? As long as your service is not disturbed,
My lord, automatically I will be terminated, my lord.
why? Who told you?
I will be reverted back to the
You find out what is happening. We'll have it after 10 days for motion. Mr. I.H. Sekel, Learned Counsel for the petitioner submits that the promotion of the private respondent number 5 to the post of Anganwadi worker is a signal to the petitioner that her services will be terminated without following the due process of law. Although the petitioner has been working,
He will be reverted back to the Anganwadi helper.
is a signal to the petitioner that she would be reverted back to the post of Anganwadi helper without following the due process of law. Mr. C.S. Hazarika, Learned Government Advocate Assam, prays for a week's time to obtain instruction and appraise this court. Prayer allowed 2 extra copies of the writ petition be furnished to Mr. Hazarika. Register to list this matter again on 6th of February 2023 for motion. We'll set it aside if they can't satisfy us.
As per my
Sorry,
instruction,
motion.
my lord.
Yes.
As per my instruction, my lord, the private respondent is going to be appointed today, my lord.
Let it be appointed. If they can't satisfy us, we'll set it aside. That's all. Matter-
As per my lord.
No, sorry. Next matter, please.
My pleasure, Lordship, my lord, in this IA, my lord,
You want to implicate whom?
in my lord, the Mehbubur Rahman, my lord, he is the head clerk in the office of the Bagbor Revenue Circle, Mandia.
Why you want to implicate him?
My
Why?
lord, we have some allegation against him, my lord, in the writ petition itself, but inadvertently we have not made party, my lord. Allegation is that because of his involvement, our name has been excluded in the forwarding letter for revised pay scale, my lord.
Yes. who
I
is
think my
appealing?
lord, other side may not have any objection.
I am for private respondent 7, 8 and 9. Copy is not furnished to me.
For
I
Mr.
have no-
A.R. Signal and counsel for the applicant, this
I have no
IA has been filed with a prayer to implicate Mr. Mehbur Rahman as respondent number 10 in WPC number 252/2021. I have perused the statements made in the IA. Mr. Sikdar submits that although some allegations have been made against the OP number
OP1, my lord. So it's only
OP number 1, that is Mehbur Rahman, by inadvertence, he was not made a party to the writ petition. Full stop. Mr. S. Datta, Learned Standing Council, Revenue and Disaster Management Department, Assam, Mr. C. S. Hazarika, Learned Government Advocate, Assam, and Miss N. Bora, Learned Standing Council, PNRD Department are present and do not have any objection. Similar is the stand of Mr. R. Islam, Learned Council appearing for the respondent number 7.
7, 8 and 9.
In view of the above, the prayer made in the IS stands allowed. The opposite party is hereby implicated as respondent number 10 in the connected writ petition, registered to make necessary correction in the cost title of the writ petition and list the matter thereafter for orders.
my lord,
IS stands disposed of.
notice may be this.
Let it first be listed, then we'll let them correct the. Develop.
For admission, item 16.
None appears for the petitioner on call, Miss
I am D. Bora for Health and Family Welfare Department.
Ms. D. Bora, Learned Standing Council, Health and Family Welfare Department, Assam is present. First up, since the petitioner's counsel is absent today, this matter stands adjourned for 4 weeks.
Item 17 and 18.
May please, your lordship, but I was appointed in the year 1997 on completion ground by the then Deputy Commissioner Sunitpur. But till today, my service has not been regularized. Page, I take the lordship, page 16 is the appointment letter, madam. Many times matter has come up and there was a direction to take instruction. They have filed the affidavit, they have admitted everything. We have given reply also.
Which department is this?
Department of Personal Matter.
What is the other writ petition about?
Otherwise, contempt matter. Other petition was earlier, I was dismissed, terminated from the office. That's why I came over here, then honorable court has stayed that. Now there is a contempt because my salary was stopped, but after filing contempt, salary they are paying me. Fixed salary they are paying me.
Yes, who is appearing for the?
If your lordships go by the annexure 3 of our affidavit in opposition,
Annexure 3.
yes. Roman 3. It's a letter dated 14/6/2017.
Yes.
We have written this letter to the GAD lordship for considering the case of the petitioner towards the permanency of this employment. And it
Two posts are still lying vacant, but as per the application letter.
Where is the earlier order of the court? Where is the earlier order? In the first round order passed, where is it?
Well, I take your page, annexure 10, page 34. No, yeah,
But where is his order of appointment?
Yes. Page 10, 16, my lord. Annexure 1.
Yes, Mr. Sharma.
For their permanency lordship, letter has already been written to the department lordship that.
So his appointment was against a quota for compassionate appointment.
Yes.
So there is no question of further selection or regularization,
Lordship.
right? So although the learned single judge has observed that he cannot claim regularization as a matter of right, perhaps that observation was made in the context that ordinarily, if you are recruited without following a regular process, then you have to undergo a regularization process, which is in accordance with law. But this is a special category appointment.
But lordship, most probably he was not appointed in that category of 5% compassionate appointment quota, and I think no approval has also been taken from the finance. No?
At that time, that provision was not there. 2097.
So according
So
to
now, what do you do with him?
Here, the issue was, pursuant to the policy of 1983 regarding commissioner appointment, that order was issued by the deputy commissioner. Now, whether the procedure prescribed in this policy or this notification was followed or not, the deputy commissioner will have to reply, my lord. Because in 2005, after giving the appointment in 1997, for the first time in 2005, deputy commissioner wrote to the government for granting regular scale to the.
Mr. Gogoi, these are your interdepartmental
I
issues.
understand.
You are asking the court to go into these things.
And here, my lord, there is already a direction. The deputy commissioner must consider and pass an order, my lord, speaking order, whether he will be entitled or not.
No, since 1997, this person is working, he will definitely have to be absolved.
No,
What do you mean?
presently he is not in service.
Yes, I'm working.
No, my lord, his own statement that from my lord 22 to.
No, I was dropped, but I again given.
Otherwise, compassionate appointment is a regular appointment. There is no doubt about that. Here,
The process was not followed, initiate action against the then deputy commissioner. Otherwise, we will not consider it. What are these poor people going to do?
lordship,
They are not experts in law. All they want is something for survival.
lordship.
may I suggest lordship? As because he is working from 1997, a direction may be given from this honorable court to regularize his services, lordship. That will end the matter, lordship. As because he is working from 1997, we cannot.
No, regularization after Umadevi, it will be difficult. Well, Pendas is there.
No question of regulation.
Regulation.
His appointment.
Yes,
is
yes, as compassionate appointment, lordship.
That
Compassionate, on compassionate ground.
Yes, lordship. On compassionate ground, lordship.
otherwise entitled.
And therefore, the further regularization does not.
As because he is now also getting the salary also because of that interim order passed by
Yes,
the honorable court.
getting salary.
Fixed pay.
Fixed pay, no?
Fixed salary.
Yes, fixed pay, fixed salary.
Fixed pay.
But my lord, if whether he was actually entitled or not, my lord, that should be ascertained. Otherwise,
No,
my
but
lord,
how do you expect people to go into those things 1997 and today? How is it possible? Are these people, can they get a battery of lawyers to back them up?
no, my lord, at least the deputy commissioner must verify that, my lord.
That you do it, you ask him why he is given.
Only that, my lord, observation may be there. That observation may be there, my lord.
No, if there are any procedural lapses by the deputy commissioner, that cannot be at the cost of the petitioner.
My lord.
He had made an application, he was appointed against a vacancy of compassionate, whatever, on compassionate ground. Having done so, this issue cannot be reopened. It cannot be reopened. 1997, today we are in 2023.
Lordship.
How many years down the line?
32 years is already completed.
These issues cannot be reopened, Mr. Gogoi. You find out your way. What you want to do is up to you. The court is not saying that there is some wrong intention on the part of anyone, but the fact of the matter is, these are people who are in dire need of an employment to support their family. You can't show them technicalities of law. You are not showing it to people whom you should show. And you are choosing them to teach them law. Heard Mr. S. C. Vishwas, learned counsel appearing for the writ petitioner. Also heard Mr. S. Sharma, learned additional senior government advocate Assam, appearing on behalf of the respondent numbers 1 and 4. Who is for the land revenue department? Why disaster management has been made a party?
No, the
You thought there will be a disaster in this case?
his father was working in as a mondal.
Acha. Also heard Mr. S. Datta, learned standing counsel, Revenue Department, Assam, appearing for respondent number 2, and Mr. B. Gogoi, learned SC Finance for respondent number 3.
So I appear for 1 and 3, my lord.
Acha.
GAD, I'm appearing.
Oh. Well, 1 and 3?
Yes.
Myself is 4 lots.
Huh? You got it, yeah? By filing this petition, the writ petitioner has approached this court for the second time, seeking a direction to pay him the regular pay scale in the post of peon. Full stop. The facts of the case, briefly stated, are as follows. Full stop. The father of the petitioner died in harness on 14/10/1992 while he was working as a lot mondal under the establishment of Deputy Commissioner, Sonitpur, Tejpur. Full stop. Since he was the only bread earner in the family, an application was submitted by the petitioner. Now, since he was on the demise of the bread earner of the family, the writ petitioner herein was appointed on compassionate ground at a fixed pay of ₹900 per month in a grade 4 post on temporary basis by order dated 6/8/1997 issued by the Deputy Commissioner of the district. That is the respondent number 4. Full stop. Accordingly, the petitioner continued to serve in the post of peon since 6/8/1997 at a fixed pay of ₹900, which was subsequently enhanced to ₹4,500. Full stop. However, with effect from the month of March 2014, the salary of the fixed pay of the petitioner was also stopped up till January 2017. Agreed thereby, the petitioner had approached this court by filing WPC number 2557 of 2015. Which was disposed of by the learned single judge by order dated 26/8/2016. Full stop. The operative part of the said order would be relevant in this case and therefore is being reproduced herein below. You will find it double tick in page 35, double tick to double tick. Full stop. Even after the order dated 20/6/2016, the petitioner was neither allowed to render his duties nor paid his salary, as a result of which contempt case number 445 of 2019 was instituted for alleging violation of the directions of this court. Full stop. Consequently, the petitioner had been allowed to resume his duties and has also been paid the arrear salaries up to
Now the arrear salary not fully cleared, but now he is getting about 19,000 salary per month.
a part of the arrear salary. Full stop. Mr. Biswas, learned counsel for the petitioner, submits that the petitioner is continuing to render his duty in the post of peon on regular basis by drawing a salary of rupees 19,000 per month. Then what is the problem?
Beg your pardon?
What is the problem then if he is drawing salary?
But my service is not regularized. I am not getting regular pay scale. That is a fixed salary.
The amount that is getting is the minimum of the pay scale.
Minimum pay scale.
Now he has been given that amount.
However, according to the petitioner's counsel, his client is petitioner's counsel, he is entitled to higher pay scale, which is why the petitioner has been compelled to approach this court by filing the instant writ petition. Mr. H. Sharma, learned additional senior government advocate, Assam, has invited the attention of this court to the amendments made in the affidavit in opposition filed by the respondent number 4 to contend that initially there was want of government approval in case of the petitioner's appointment, as a result of which there were some hiccups. Full stop. However, ultimately, once the issues are resolved, the petitioner is now being paid the minimum of pay scale applicable in his case. First of similar is the stand of Mr. B. Gogoi.
Approval, Lordship, he has not, it was not yet been given.
That
Yeah.
approval has been given. For the
No,
minimum of pay
A
scale.
minimum pay scale that was.
Mr. B. Gogoi, learned standing council finance, has also confirmed
Yes.
that the finance department has given the approval for payment of the minimum scale pay scale to the petitioner. And accordingly, he is receiving the basic pay of rupees 19,000 per month. Full stop. Next paragraph. In the writ petition, the basic relief sought for is for regularization of the petitioner in the post of peon. Full stop. However, it is seen from the materials on record that the appointment of the petitioner was on compassionate grounds. Full stop. Thereafter, the finance department has also accorded approval for payment of the regular pay scale to the petitioner, and he is presently discharging his duties in the post of peon by receiving salary as per minimum pay scale. Full stop. Since the appointment is on compassionate ground, the petitioner cannot be treated in equal footing with other employees appointed on temporary basis. Full stop. Therefore, this court is of the opinion that there cannot be any further question of regularizing the service of the petitioner in the grade 4 post. In other words, the petitioner, for all intent and purpose, is discharging his duties as a regular employee under the establishment of respondent number 4 in a grade 4 post. Full stop. To that extent, no further direction is called for from this court. Full stop. If the petitioner is aggrieved due to aggrieved by the fact that he has been granted the minimum pay scale applicable in case of a grade 4 employee, then it would be open for him to approach this court by agitating his grievance in such regard by bringing the proper facts Full stop. Therefore, this writ petition is hereby closed with the above observation by granting liberty to the petitioner as prayed for. Next, contempt case is also accordingly closed.
Well, may I pray for to
There
add
is no
one
question
line?
of regularization here.
Yes, your lordship has given the
Yes,
observation that
yes,
automatically.
Yes.
Yeah, but area payments, if any, may be paid.
Now, have you prayed for area?
But to my information, the area there are still some dues.
No, but we can't because it is finance department. Unless you make a prayer, they will have to obtain instruction. How can we give it?
Right, I'll come again. If
Though this court
your
is,
lordship has given me liberty.
though this court is sympathetic to,
Maybe very much, my
but that doesn't mean we will.
I am not praying.
This is financial matters.
Really.
We have to follow the norms.
Yes. We have
On
to-
what basis he will give a, he'll take a stand. He doesn't even know
Yes,
what you are asking for. You may have a case, but then you agitate it.
And all the friends have considered my case, but
Of course they are.
I'm happy that after 97 to 32 years, I've got some relief at this.
All right, yes. Yes.
Item 19.
I undertake to file fresh copies, Millard, because the confusion has arisen on account of, Millard, the fact that there's another writ petition. So the department seems to have given that copy, but I undertake to file, serve them a fresh copy today itself, Millard.
No, but then the matter will have to be listed on on Wednesday then. Are you available on Wednesday?
Millard, I'm not.
Mr. Phukon, this court cannot pass an order on assumption that tomorrow you will give another copy. That copy will show somebody as respondent number 4. On that basis, this order cannot be passed. by
Millard,
this
may
court.
then kindly keep it on the 8th, Millard.
All right. On the request of Mr. A. Phukon, this matter is directed to, this is item number
9.
9. This matter is directed to be listed again for motion on 8/2/2023, so as to enable the petitioner's counsel to furnish corrected copies of the writ petition to the learned departmental counsel. I'm sorry, you are traveling from outside, but we cannot help it.
I bow down.
You have to, we cannot pass orders which are erroneous and then it turns out creating more confusion. That's not possible. If a mistake has happened, it has happened. It's unfortunate.
My lord.
Rectify it.
Item 19.
Please, Your Honor, I simply pray this case to be deferred the case for 1 week. Mr. Adas is conducting this case and due to his personal inconvenience, he could not come.
What is this matter?
Earlier also there for time.
No, this is the
Your
first time you have to come.
I'm for the workman, order was passed for, award was passed for reinstatement of the workman. Still, they have not paid the 17B was also not complied with. Because Peter in the P estate. By the order dated 12/3/2018, order was passed for compliance of 17B. Till date, they have not complied with, only for instruction they have taking time.
Your Lordship, on last occasion, they have filed the affidavit of our compliance of the 17B. So to that effect, we need some instruction also. So to reply their counter affidavit. In this case,
You want time for what?
I actually, since my learned friend raised the question, that's why I simply want for deferment this case, Mr. Adas is doing this and he is conducting this. On behalf of him, I'm.
Okay, where is Mr. Adas?
Mr. Anirbandas,
Where is he?
due to his personal inconvenience, he could not come.
We'll take up this matter on Thursday, with or without Mr. Adas. On the request of learned counsel for the.
Your Lordship, can you 1 week time maybe given your.
You know, wait till Tuesday.
Next Thursday, Lordship.
7th. Mr. K.L. Gupta, counsel for the respondent is present. Upon on the request of learned counsel for the petitioner, this matter stands adjourned till 7/2/2023. So is present for the respondent number.
1, this one number.
No further adjournment on the next day. Yes.
Item 20.
Lordship, Lordship, my senior counsel is out of station for today, so kindly adjourn the matter for a day.
You are appearing for whom?
SS Roy, Union of India, on behalf of all the respondents.
None appears for the petitioner on call. The respondents counsel has also sought adjournment in this matter. In view of the above, his admission hearing of this writ petition stands adjourned for 4 weeks.
Item 21.
May I please, Your Lordship. The case of compassion appointment, Lordship, and there was an order, Lordship, order dated 5/12/2022. Lordship. Second
What
round
is-
of litigation.
Who is for the
Yes, yes,
department?
come.
Sorry, Lordship.
Yes.
In this matter, they have filed an additional affidavit in Lordship, which they have stated that the case can be considered in next SLC meeting, Your Lordship. The petitioners filed an additional affidavit where they have stated that this case may be considered in the next SLC meeting, but there's a delay, Your Lordship. Round of delay.
What is your instruction as per order dated 5/12/2020?
As per original Lordship, similar matters where he has, we haven't received any instruction, but similar matters were dismissed, Your Lordship, stating that since he has not made any of the person a party, he is showing a select list where he has not made any of the persons who were selected as a party in the petition, Your Lordship. It was dismissed on the basis of joined or necessary party.
When did, who died? Who died?
His father died, Lordship, in 1997.
23?
1997.
203/1997.
And when was the application submitted?
It was, Lordship, on 23/5/2023. Initially, Lordship, his mother, Lordship, pursued a case, Lordship, but subsequently, Lordship, when this petitioner become major, so Lordship, the mother requested the concerned authority to consider his application. Accordingly, Lordship, process was initiated. And this is the second round of litigation, Lordship. First order is there, Lordship. All those condition has also already gone, Lordship. Case 23, Lordship, the first order.
You can't get appointment on compassionate ground, Mr. Khalifa.
Lordship.
That's the final answer.
No, Lordship, already they have considered my application. Lordship, see the,
They have considered that to be withdrawn. They cannot consider.
no, Lordship, kindly see the case 25, Lordship.
You finish your arguments, then I'll dictate the order.
If Lordship,
You know the reason why it cannot be done.
because of delay, Lordship. Or Lordship.
Why because of delay, these applications cannot be considered? Do you know the reason?
So delay is, Lordship, not because of this petition, it's because of the, Lordship, fault of the responding authorities, Lordship. Because, Lordship,
You know the reason. It will help you in another case. At least you should know.
Lordship.
You don't seem to be aware. Huh? These are minimum understanding of legal principles which you should have when you're standing in the court. Otherwise, you can make your submission, we can pass our orders. This compassionate ground appointment is not a regular process of appointment.
Yes.
There are hundreds of people in the society who seek. This is an exception carved out to give immediate relief to the family.
Yes.
Once a bread earner dies, immediately some relief is to be given. So this is created. Somebody who dies in 97, there is no question of giving immediate relief in 2023. That you agree? Now, this is barred under the government notification also.
Yes.
That is why
Yes.
you can take the order of dismissal today or on some other date. That's the only point you can argue.
Lordship, some other day, because.
Some other day. Okay. So to come to the point which you are interested. Some other day, which day?
Lordship, after 2 weeks.
2 weeks will be enough or even 4
Same
weeks?
matter also I can put it.
2 weeks may not be enough.
Sorry. No, Lordship, may I submit one thing? Lordship will adjourn the matter for today, Lordship. That's my humble submission, Lordship. Fact is that, Lordship, since 1992, Lordship, up to 2015, no appointment on compassionate ground was made by the respondent authority.
Mr.
Oh,
Kalita,
yes.
the government notification was challenged and the division bench dismissed it. What can I do?
Lordship will adopt this
You may have a point that these circumstances, what is the way out? But that notification has been affirmed by the division bench. Can the single bench now take a different view?
without
You are not aware. You are not aware of the division bench judgment. You are not aware of the notification. Or even if you are aware, you don't want to admit it. But unfortunately, the court is aware what to do.
Lordship, so so far my knowledge goes, Lordship, I am aware about all those judgment passed by the Honorable Court and the notification also, Lordship. But in other court, Lordship, I have, Lordship, this kind of cases, Lordship, minimum 40 to 45 cases I have filed, Lordship, and all cases I have get positive order, Lordship, from the other court, Lordship.
Which court? Take it.
Lordship, Lordship, in other court.
Other court.
Other court, Lordship.
So you wait for other court.
Lordship, after 2 weeks.
4 weeks, yes.
After 2 weeks.
On the prayer of Mr. J. Kalika, and the counsel for the petition. Have these orders been implemented?
Yes, Lordship, all persons have been appointed, Lordship, subsequently.
As
Lordship,
far
I
as
can
my
put it
instruction,
all
I don't have
documents.
that instruction, Lordship, whether they are appointed or not, because as far as I know, there are no more vacancies for compulsion appointment, Lordship.
Lordship,
On the request of Mr. Kalita, let this matter be listed again on 2nd February 2022. You show me the orders. You have
orders,
got
Lord, I'll put it. Same thing, Lordship, item number 23 also.
23 same.
Lordship, I'll put it.
Show me the orders
Yes,
and
Lordship.
show me the implementation order.
Lordship, I'll put it, Lordship, yes.
All right.
Item 22, sorry, Lordship, item 22, 1 and 22, 21, 22, Lordship, not 23.
25.
May please, in earlier order, item 19, interim order, very particular.
25, 26 and 27.
Interim order.
In 25, Lordship, we have already paid the pension and other benefits, Lordship.
25. 25, 26. My lord, in this case, my lord, order was passed, my lord, this honorable court, my lord, giving the, my lord, retrospective, my lord, promotional benefits to the petitioner, my lord. Then they, my lord, filed review petition, my lord. And review petition was also dismissed, my lord. But later, my lord, I am, my lord, given the promotional benefit with only, my lord, prospective benefit, my lord, effect, my lord. So, my lord, in the meantime, my lord, but before filing of those petitions, my lord, this incumbent already retired, my lord. So, my lord, I have taken instruction, my lord, he will be satisfied, my lord, the national promotional benefit is.
A promotional issue, my lord, it will require some hearing, can it be on a hearing matter?
Why 3 writ petitioners?
My lord, it is stage by stage, my lord, it is filed, my lord, because initially, my lord, the last one, my lord, filed, my lord, during the pendency of this petition, my lord, they filed one affidavit, my lord, where it was, my lord, seen, my lord, one, my lord.
Well, will issue rule. He has already retired.
Yeah,
He is receiving his pension.
Yes,
Yeah.
regularly.
All right. Will issue rule and fix it for hearing. Yes.
Any admission stage,
No,
because, my
no,
lord, this is,
no.
my lord, matter of.
No, everybody wants everything in admission.
My lord,
Sorry, not possible.
matter is, my lord, 2019, my lord. Otherwise already delayed, my lord, 5 years is gone, my
All
lord.
right. And
Well, it is a small matter, my lord, already.
Mr. A.M. Borbian and counsel for the writ petitioners. It appears that in all these writ petitions, the basic relief claimed by the petitioner is to the effect that the promotion given to him must be given retrospective effect on a notional basis so as to calculate his pensionary benefits. Mr. B. Gogoi, Learned Standing Counsel, Finance Department, Assam, and Mr. R. Dhar, Learned Counsel appearing for?
That's one number 6, Lord. That's one number 4, sorry. Accounting general. In item number 27.
For the tax department.
Accounting
Yes,
general.
Huh?
Accounting general.
Tax I am preparing, my lord. Finance taxation I am preparing.
Accountant General Assam, as well as Mr. A. Hassan appearing for the, as well as Mr. A. Hassan submits that the petitioner has already retired from service and he is regularly receiving his pension and other benefits. Therefore, there is no urgency in the matter. First of having heard the submissions of learned counsel for both sides, this court has the opinion that these matters will require detailed hearing. As such, issue rule returnable in 6 weeks. Since the respondents are already represented, no formal notice is required to be sent in this case. Extra copies be furnished to the learned departmental counsel. Register to list these matters for hearing in usual course. Yes.
We have already filed a affidavit, the extra copy is not necessary.
Extra copy.
Not necessary.
Since the respondents are already represented, no further notice is required to be sent in this case. Register to list these cases for hearing in usual course. Yes. Mr. Borbuya, you see, don't think that we are only interested in your client. These are not matters which should get precedence over people who are services are terminated. Don't repeat it. Well, you want it in admission. What is your submission? You want the matter to be heard in admission. Why? Only because it is.
Hearing, maybe,
Yes.
but in the daily list, my lord, kindly, my lord.
Sorry. Yes, next matter, please.
Apply.
My lord, subsequent to a regular selection process, the petitioner was appointed in the district court Baksa establishment, my lord, in the post of sweeper. Thereafter, he was released. That is the case. The impugn order is at page 54, annexure 20. And this matter was earlier heard at land. Lordship may kindly peruse the order dated 9/12/2022.
This is a part-heard matter.
Not, it was not kept as part heard, but Lordship, the order dated 9/12/2022, my lord.
9/12.
Yes.
Yes.
Well, that instruction is negative, my lord. By order dated 9/12/2022, as well as 9/1/23, some direction was given to final inspection. That is negative, my lord. Can it be, my lord, after 7 days? My lord?
My lord, I have all the documents, my lord, I'll place before this court, my lord. On last occasion, I already placed one OM that is kept as Annexure X. That is, my lord, order dated 9/1/2023. That is already placed. Then there is a judgment of this honorable court, division bench judgment. That also I have got a certified copy. Now, my all documents are there. A small issue, it can be heard, my lord.
So that or that instruction which was called for by the court according to you is not necessary.
Whatever was called
Yes
for,
or no, tell me.
that is necessary, I have placed that.
Then we'll adjourn it.
My lord, I have placed those, my lord. Those OMs I have placed, my lord. Already on last occasion, I placed one. And everything I have, my lord, I'll place.
What is the OM dated? What is the OM dated 3/7/2000?
My lord. OM dated 3/7/2015 and OM dated 4/9/15. And also this, another court wanted to know about the judgment passed by this honorable court in WPC number 6222 of 2003.
No, whether the office memorandum dated 33/2012 will be applicable in the instant case. Where is 33/2012?
Page 19.
So is it correct that all these information are already
No,
on?
my lord. In fact, my lord, in page 18, there is certain concurrence given by the finance department. Those documents were, my lord, sought for. That is everything. Not OMs, my lord. These are internal documents of the finance department, which was given to the judicial
Then
department.
Mr. Khan, if these documents are relevant, then how can we proceed?
Then
in
my
the matter?
lord, in that case, my lord, they may be given the last opportunity to produce that file, my lord, on the next date, because they are delaying it, my lord. I am without any employment. I have been appointed by a regular.
Yes, give an undertaking. When will you?
My lord, after 10 days, my lord.
All right.
We have already communicated.
Mr. F. Khan, Learned Counsel, hearing for the writ petitioner who submits that despite the specific directions contained in order dated 9/12/2022 passed by this court, the relevant file has not yet been produced before the court. According to Mr. Khan, the delay in disposal of this writ petition is causing enormous prejudice to his client, who is presently without any employment. First up, Mr. B. Gogoi, Learned SC Finance, submits that instructions as called for are yet to be received, and therefore the department be granted one final opportunity to produce the relevant materials as called for by this court. First of, after taking note of the submission of the petitioner's counsel, the registry is directed to list this matter again on 16/2/2023 for admission as a fixed item. On the next date fixed, the Learned SC Finance, Mr. B. Gogoi, to positively produce all materials called for by this court necessary for disposal of this.
May I please, Your Lord, sir?
Yes,
Lord, 2 weeks time may be granted for filing a reply. Maybe.
reply or rejoinder?
Reason-
Huh?
Response to our affidavit in opposition.
All right, on the prayer of Mr. B. M. Dekal, Learned Counsel for the petitioner made with the consent of the other side, this matter stands adjourned for 3 weeks so as to enable the petitioner to file rejoinder in response to the counter affidavit filed by the APDC.
Not so late.
List accordingly. Mr. B. Chaudhary, Learned Standing Counsel, APDC is present. List accordingly.
Deeply well.
Item 30.
Item 30, request for a passover in the time being, Your Lordship.
What is the matter?
Lordship, in this matter, actually, the petitioner, he's present in the post of executive engineer, and he wanted a promotion to the post of superintendent engineer, Lordship. And there was
Which
a
department?
Lordship, agriculture department.
Hmm.
Lordship, there was a disciplinary proceeding at one point around 2017, and that time one increment was stopped. However, subsequently, after that penalty was over, he was paid. But then now when he has applied for promotion, he has not been given his promotion on the basis that there was a disciplinary proceeding that time.
The penalty is expired on 36/2022, Lordship. The last year, June, Lordship, and in the next DPC, he'll be considered, Lordship.
Lordship, that is their contention.
Lordship,
However, in 2017 itself, that penalty was over, and then he was subsequently given his increments, Your Lordship. So that period technically has already been in 2017 it has passed.
So
Your
you should have
Lordship.
got an order to keep it in seal cover. Have you got it?
No, Your Lordship.
Then you
The
missed
Lordship,
it.
initially when they were considering the promotion, that he's not promoted, that was kept in the seal cover.
No. Where is the seal cover? Order for seal cover. Where is the order of the court for seal cover? You find out, we'll call it up after 10 minutes. After 15 minutes, we'll call up, you find out. If there is no order for seal cover, matter is over.
Lordship, however, in the last occasion, the respondents were supposed to bring instructions as to why the matter.
No, she's saying the panel has expired. Next time when the DPC is held, your client's case will be considered. You cannot set the clock back. Only that is why the recourse under the law is that you take an order to consider his case in seal cover. And if he is exonerated, that cover will be opened and given effect to. If that consideration has not been made, now there is no way there can be a consideration of the previous panel. That's the law. All right. You can take some time to examine the law, but that's the law.
Lordship, I have to
So
maintain-
we are giving you that time, enough time, 15 minutes. Yes. Is it less time? 15 minutes is not less time. All right.
Item 31.
None appears for the petitioner on call. You are there for whom?
Lordship, for all the respondents, Lordship.
Miss-
One, two.
Miss-
Eight Talukdar.
Ms. A. Talukdar is present on behalf of respondent numbers 1 and 2. However, since the petitioner's counsel is absent today, this matter stands adjourned for 4 days. Yes.
Obliged, Lordship.
Item 32.
May I please, Lordship? My lord, the case of the petitioner is a consideration of the compassionate appointment, my lord. The district level committee recommended, my lord. And state level committee, my lord, rejected, saying, my lord, the post is not available or saturated, my lord. The language was that, my lord. Case 31. So there is a vacancy position in the office, same office, my lord, who have obtained the vacancy position.
Mm.
They could, my lord, consider if not there are other department also, my lord. There are existing laws there.
When was the application submitted?
Application submitted, my lord. In time, my lord, we have submitted. From the DLC minutes, it reveals, my lord. At page,
When, who died?
my father died.
When did he die?
He died, my lord, 19/1/13,
2013, Lordship.
2013.
And when was the application filed?
In due course of time, my lord, that minutes will reveal, my lord.
No, I'm not asking whether due course or not. I'm asking what is the date?
Date has not been mentioned, my lord. Only
Mr.
DLC
Borga, it will not be possible to write out an order without this.
My lord, DLC has recommended, my lord, as you will see. That means, my lord, he has filed the application. In
That means to you, not to the court.
my lord, it reveals at page.
There are
24.
many things which will mean well to you, but we can't help it. The court order has to be written on the basis of materials on record.
My lord,
When was the application submitted? Even if it is reflected from the DLC order, that is fine. But it must be there. The information must be there.
or my lord may come up some other day, my lord.
Yes. Yes.
That is next week.
You have, what is your instruction?
Lordship, as per our instruction, Lordship, may I read, Lordship? As per the vacancy position submitted by Guwahati Division, a number of appointment on compassionate ground had already been made in the cadre strength of Khalasi, which implies no further appointment on a compassionate ground is possible against a cadre strength of 22. Therefore, SLC considered the application of Sri Vinal Das and Sri Ratan Thakuria, the father of the petitioner, under para 14A by clubbing beyond Chokidar, helper and APPO post, even after clubbing that only one extra post within the prescribed 5% quota could be found against total cadre strength of 28 numbers. However, as the father of Sri Ratan Thakuria had expired on month before the petitioner's father, therefore he was considered lordship, not him. So no available vacancies there.
My lord, if it is not there, my lord, in the other department also they can send, my lord. There is a judgment also, my lord.
Then let her first file affidavit.
Yes, that will be.
Heard Mr. J.I. Borvian, counsel for the petitioner, also heard Ms. A. Talukdar, and counsel appearing for the respondent, who submits that she has received written instructions in this case, and therefore we permitted 3 weeks' time to bring the same on record in the form of an affidavit. Prayer allowed. Affidavit be filed within 3 weeks by serving advance copy upon petitioner's counsel. Register to list this case again after 4 weeks.
Well, the date may be fixed,
All right,
but otherwise
4
very
weeks.
difficult.
Yes, yes.
Item 33.
Very good. The petitioners promoted Mellon by office order dated Mellon.
What is the interim order here? What interim order
Status
is
quo Mellon.
status quo regarding what?
Really, Mellon, office order is there, Mellon, kept in evidence that promotion order, Mellon. That was kept in evidence on the status quo, Mellon.
Where is that order?
Mellon,
128.
So if the promotion order is kept in abeyance,
yes, Mellon.
then promotion to which post?
Superintendent, Mellon. From
So-
EDA to superintendent, Mellon.
So who is now the superintendent?
Mellon, there are some, now, Mellon, there's few posts, Mellon, superintendent post, Mellon.
Who is the superintendent in that post today?
Today, Mellon, I'm not aware today who is that, I am also superintendent, Mellon, as per this status quo order, Mellon, I am holding the same post, Mellon. But is this in another department, Mellon, another section, Mellon.
So what is to be done today?
Mellon, similarly situated person, Mellon, by the same order.
You are asking for disposal,
Yes, yes.
final hearing.
Yes, Mellon.
You are also ready.
Not today, Malad. Can it be as other date, Malad, if possible?
Today is not good day.
Malad, some untoward incident happened, Malad. I had to reconstruct the file. Malad, I had to reconstruct the file today, Malad.
He is not
Otherwise,
ready.
any date, Malad.
Mellon, can it be on any hearing, day, Mellon, for discussion?
All right. Mr.
Yes, I think.
A. Zahid, Land Council is present on behalf of the petitioner and submits that this matter is ready as regards pleadings and can be taken up for final disposal. First up, Mr. P.K. Munir, Land Council appearing for the respondent number.
3, 4, and 3, 4, 5.
3, 4, and 5.
6, 7. 3, 4, 5, 6, 7.
Land Standing Council, Assam Khadi and Village Industries Board appearing for respondent number 3, 4, 5, 6, and 7 submit that he is not ready to argue the matter today and therefore the matter be posted again after 2 weeks. Mr. Ardhar, Land Standing Council. Handloom and Textiles Department, Assam is present on behalf of respondent numbers 1 and 2. In view of the request made by Mr. Munir, registry is directed to list this matter on 21/2/2023 for admission hearing as a fixed item.
Interim order may continue.
Interim order passed earlier to continue till.
Item 34.
May I please, Your Lord?
Yes.
My lord, I am an orphan, my lord. After retaining majority of 18 years, I have applied for completion appointment, my lord. Now they are saying you are too late. I have lost my father, I have lost my mother. I have been adopted by somebody for my education.
No, when did the father die?
My father died in 2004. Then my mother died 2010.
Both were government servants.
No, my father was government servant.
Then don't bring mother in this. Father died in 2004.
Yes.
Then when did you apply?
We applied, my lord, after attaining a majority, my lord. That is in 2000. Well, I take you page 25, can you?
When did you apply?
25. Oh, sorry. On 11/6/2010, mother expired. Then after mother expired, I was 8 years old at that time. Then when I attained 18, I applied.
When did you apply?
My lord, I applied in my lord 2020, my lord.
Where is it? Where does one?
Page 26, my lord. Date night. This copy.
So what has happened to your application?
Well, they said I am too late. That after that I have come before your lordship, my lord. My landed friend have not
Where,
yet. filed.
where is it? Where have they said so?
Last time, the reject of.
My last, I take your lordship, my lord, page 29, last annexure. 14 September 21.
Yes. So this is wrong. According to you, this finding is wrong.
My lord, I am the actual person, my lord, having no parents, my lord. I need a job for my survival. And it is fact that I was late because I was minor. Your lordship is to consider whether the minor.
Mr. Biswas,
Yes.
you may or may not be aware. Even if you are aware, you may or may not like to admit. Hundreds of cases with similar grievance has been closed by the High Court. There is a division bench judgment, there is a government circular, there is a Supreme Court judgment. This cannot be helped. Many people are
Give
minors.
me 2 days time, I will give you some judgment.
Take 2 weeks, it will be better for you. Hard Mr. S.C. Biswas and counsel for the petitioner who prays for adjournment in this case for 2 weeks. None is appeared for the respondents to oppose the prayer. In view of the above, let this matter be listed again. As prayed.
Judgment by court.
Item 35.
Lordship, in this case, respondent number 1 and 2 filed their affidavit in opposition to them. 2 weeks time may be granted.
I appear for respondent 1 and 2. We have filed it today itself.
2 weeks time may be granted.
Right. Mr. J. Lashkar and counsel for the petitioner press for an granted 2 weeks time to file rejoined in response to the counter affidavit filed by the respondent numbers 1 and 2. Today, that is put the day. Mr. A. Kalita, learned counsel is present on behalf of respondent numbers 1 and 2 and Mr.
3 and 4. 3 and 4. I find my affidavit.
Right, and Mr. So-and-so, for respondent numbers 3 and 4. List the matter accordingly.
Obliged.
Item 36.
Lordship, this matter is similar to WBC 3974 of 2022. Lordship. That matter came up on Friday and there was a rejoinder filed in that matter, Lordship. So, Lordship, there is already an order in that matter to take these 2 matters together and take it up. Is this to be listed after 2 weeks, Lordship? This may kindly be taken up then, Lordship.
Mr.
I'm MP
Sharma, MP Sharma, learned counsel for the petitioner is present. Also heard Miss J.P. Das, learned counsel appearing for the respondent. It is submitted at the bar that there is already an order by the court to list this matter along with WPC number
3974 of
3964.
Yes, Lordship.
One is 3974 and another 2 days 3964.
No, which is the other matter?
3974.
3974 of 2022, which is analogous to the present proceeding. In view of the above, register to verify and list both the cases together after 2 weeks.
Yes.
Item 37.
May I please, Your Lordship? Instruments before your Lordship are working at Ward Boy IRS in the recruitment college and hospital. My lord, they have been rendering more than 10 years of service. However, my lord, they have been drawing a fixed pay of rupees 9,000. Whereas the regular employee in the same capacity are drawing a pay bill, my lord, much higher to them. But should kindly turn to page 45 of the petition.
Is the mic not working? No.
Lord,
Page?
will turn-
Yes, yes.
Lord, will kindly turn to page 45 of the report.
Page 45.
Yes, and at 11.
Yes.
This is a letter written to the Director of Medical Education by the Superintendent of the Assam Medical College and Hospital, Dibrugarh. May I just read, my lord, just one letter. With reference to the above, I have the honor to bring to your kind notice the following facts about government wage earners at AIIMS Dibrugarh under the establishment of the underside. The total 27 numbers of government wage earners are presently working at AIIMS Dibrugarh under the establishment of the underside. Out of these 27 numbers of government wage earners, no one has yet attained the age of 60 years, and hence the question of releasing any of them from contractual engagement does not arise. Out of these 27 numbers, 8 numbers of government wage earners are drawing grade 4 scale under pay band so-and-so per month, while government notification that so-and-so dated 8/3/2019, and the rest 19 numbers are drawing a fixed pay of ₹9,000 per month, while OM dated so-and-so. The above 19 government wage earners are drawing the fixed pay per month, have spent long period in their life in rendering the services at AIIMS Dibrugarh, including being engaged in COVID-19 duties. They have crossed their age limits for any other government appointments, and some of them have been rendering their services for last more than 10 years, and rest are about to complete 10 years service at MCS very shortly. Since they are all having family with school going children, it has become extremely difficult for them to run their family, which has low fixed salary. Under the above circumstances, I request you to kindly move the government for enhancement of their service of these 19 government wage earners under prevention. So, Lordship, our chart is given in the next page. Serial number 1 to 19 are those 19 fixed pay, and the petitioner's hearing, and at page 48 are those 8 regularized wage earners, my lord. Also, we kindly see their last page, last column, my lord. At page 48, drawing pay scale of payment so-and-so, and in respect of the other 19, it's only 9,000. Where they are discharging similar nature of work.
Yes, why is this discrepancy?
My lord, because the petitioners, they have been appointed by the Hospital Management Society, the superintendent, my lord. They are not appointed against any sanction post or not by the government, my lord. They have been appointed on contractual basis, my lord, by the superintendent or the Hospital Management Society. My lord, regarding this issue, my lord, already, my lord, another case has been decided, my lord. And where a direction has been passed to consider for payment of the minimum pay scale. Your lordship may peruse.
Are you aware of that?
Yes, sir.
Paragraph 20.
You want a similar order?
My lord, here, my lord, the dishonorable court has directed the petitioner to approach the superintendent first. Then the superintendent will place the case before the government. That part is already there in my case, my lord.
Your lordship may peruse paragraph 23, relevant, 22 and 23, madam.
All right, so that is pertaining to now, what is the stand with the finance department? Who is appearing for finance? Finance is respond number?
My lord, finance is respondent number 2, my lord.
Here the health department in the administrative department, they'll first take the call, my lords, and
pursuant to their decision in the.
So if they take a call, you don't have any problem.
Lordship,
We'll record it.
Lordship, yes.
Because they are not the appointed government appointment, my lord. Because they have been appointed by the hospital management society.
So now this amount of 9,000 which is being paid, that
Yes,
is
my
coming from where?
From the contingency fund of the hospital, my lord, hospital management society, not from government, my lord. Not from government, my lord. Because
So, and the fund of the hospital management society is provided by whom?
because they have some source of income, my lord, from the OPD or OPD college registration or something like that, my lord. In all the hospital, government hospitals and government medical college, there is a hospital management society, my lord. So hospital management society, there are several numbers of contractual workers, my lord. In all the hospital and government medical college and hospitals, my lord. Recently, my lord, in another matter, the Silchar Medical College Contractual Workers Association, they have also approached this honorable court, wherein this honorable court has been pleased to pass a similar direction for payment of the minimum pay scale to them, my lord. Silchar Medical College and Hospital Contractual Workers Association, my lord. The fund they have, that has been paid to the contractual workers, that is not coming directly from the government, my lord.
So what has happened to this? Has this order been implemented?
My lord, probably the process has been initiated, my lord. Because in paragraph 23, there is a clear direction to consider for payment of the minimum pay scale, my lord, who has completed more than 10 years of service, continuous service, my lord.
So you follow the same process, you submit individual representative once again, and they'll follow it. And
Because otherwise, my lord, being
because
contractual.
you are not government employees.
Yes.
So, my lord, in my case, there is slight difference. Lordship, I have in Annexure 1 colleague, I have annexed the sanction accorded by the directorate, my lord, to engage with wage earners, my lord.
Where is that order?
Lordship, kindly turn to page 26. From 26 onwards to page 30, these are the sanctions by which wage earners were directed to sanction or accorded to engage wage earners in AIIMS.
That's correct. So it was for 6 months.
And it is continued, my lord. And
Where is the order extending it?
Lordship, I have just now shown the representation submitted by the superintendent of MCA that they're still working, my lord. And from 2018, such representation has been submitted by the superintendent. I can show, Lordship, at Annexure 7, page 37. This was the first letter issued by the superintendent to the government. Annexure 7, page 37. Then again at Annexure 9, page 40.
Can you show an appointment order of any of them?
My lord, it's reflected in the list from when they, Lordship, kindly turn to page 32.
No, is the appointment order available on record?
It's
No,
not
my lord.
available. I have
No.
claimed it. My lord. It's not available on record. I have not annexed it, but I have claimed it. If necessary, I can produce it. But the hospital authority, they have reflected our date of engagement.
No, Mr. Patwari, if you are agreeable to this order, then we can pass it today. If you want a different order, then you have to produce the appointment order.
My respectful submission before this honorable court is there. My lord, we only want the either.
No, what you want is all right, but what the court can do is in accordance with law. If you want a different order to be passed, then it has to be couched in a different language, for which you have to place the appointment orders on record. If you say that their appointments were made by the government or with the approval of the government, not as per the hospital society norms, then there has to be a finding recorded.
Yes,
How do we record a finding without the documents? So choice is two. Either you accept this kind of an order, which they are also agreeable, or if you want a different order, then you have to bring those appointment orders by filing affidavit.
Lordship may dispose of in the terms of that order, but my lord, there are already several communications from the superintendent to the government.
Mr. Patwari, you are a counsel, make up your mind. You see, you are interacting with the court. Either you agree, disagree, or tell us something else. There's no point stretching it again and again and again. If you want this order, we'll quote para 23 and say that their cases be also considered accordingly. That's all. Nothing more, nothing less.
No, madam, but superintendent later I have brought to the notice of the Honorable Court.
Yes. Then you bring the appointment orders. We'll pass a different order. All right. Mr. J. Patwari, Learned Counsel appearing for the writ petitioners pray for and is granted. How much time you want? You have to file it in the form of an affidavit.
Yes, sir.
How much time?
10 days.
10 days. 10 days time to bring on record the order of appointment issued in respect of each of the petitioners by filing an additional affidavit. Prayer allowed. Mr. D.P. Bora, Learned SC, Health Department, Assam, and Mr. A. Chalia, Learned Standing Counsel, Finance Department, Assam, are present. On the request of Mr. Patwari, this matter stands adjourned for 2 weeks. You also come up with specific instructions, because this hide and seek game will not work. The only reason I am asking for this document is that this court is conscious that when an order is passed, it must not only be implemented, but should be capable of being implemented. You see, councils are interested in getting something, and it is only creating contempt cases. This will not work in this court. There has to be clarity on what is decided, what is the right, what is the entitlement, what is the law, and then a direction will be issued. Nothing less, nothing more. Shortcuts, not possible.
Item 38.
May I please? My lord, service report in respect of respondent number 4 is awaited, my lord.
Heard Mr. AIIMS Chaudhary, Learned Counsel for the petitioner, who submits that service report on respondent number 8 is still awaited. In view of the above, let this matter be listed again after 6 weeks with appropriate office report.
Published.
Item 39.
In this case, let's say areas have been not given, so instruction was called for further course.
Lordship, as per my instruction, the case of the petitioner will be considered on this budget session, which will be held in March, my lords. I have informed the petitioner, my lords, 2 months' time may be granted. In the meantime, the entire process could be completed, my lords.
Heard Mr. D. Mohanto, Learned Counsel for the petitioner, also heard Mr. S. Chaudhary, Learned Counsel.
Contempt number 3.
Counsel appearing for
Contempt
the
number 3.
respondent number 3, who submits that necessary steps for implementation of the court's order has already been initiated, and the arrears salary allowance payable to the petitioner will be processed and released during the budget session, upcoming budget session in the month of March 2023. As such, Mr. Chalia seeks posting of this matter again in the first week of April 2023. Mr. Mohanto does not have any objection if the prayer is allowed. In view of the above, let this matter be listed again in the first week of April 2023. Yes.
Item 40.
Yes, your lordship. Lordship, order is in place. Lordship, email lordship. There was a direction to consider the case of the petitioner lordship as per the paragraph 22 of the division bench lordship for minimum pay scale lordship. So the
Petitioner is working at what?
working lordship, pay scale lordship, he is LDA lordship, junior assistant in the office of the Kalain Antolik Panchayat lordship.
His appointment was by following a regular process against a vacant post.
Lordship.
Where does one find it?
Lordship, he is lordship.
Where is his order of appointment?
Lordship, I have not analyzed lordship, but.
All right, on the prayer of Mr. Nath, what do you have to say?
My lord, in this case, lordship disposed the matter on November 2019. The direction was to verify and then whether he pays or not. Then the department has taken up the matter, they made an inquiry and they've submitted the report to the government. Government sent a matter to the finance department. Now, lordship is aware about one of the facts. Whenever there is a financial implications, my lord, we have to take approval of the finance department. The moment we send this entire matter to the finance department, they sent it back to us to re-examine. 4 times we have examined the matter, we have sent to the finance department the 4th occasion. Now again, finance department has written to us to verify, my lord. So again, we have verified, and now after verification, in the last week of December, we received the verification report and we will send to the finance department now. So
Finance department was not a party.
that's the thing.
And the
Should have been in the
earlier
repetition.
decision is not party.
We'll close it. You file a fresh petition. Heard Mr. AIIMS, Majumdar Learned Counsel for the
Lordship,
petition.
I may be allowed to give the instructions to appeal also.
Yes, my lord.
Also
I think that will
heard
help
Mr.
you.
Nath, Learned Senior Counsel assisted by Mr. A. Bhattacharjee appearing for respondent numbers.
One respondent, number 1, sole respondent.
Sole respondent who submits that in terms of the order dated 29/11/2019 passed by this court in WPC number 8695 of 2019, the department, the respondent has done his part.
Yes.
And the matter was sent to the finance department seeking necessary approval. However, the finance department has not accorded concurrence, as a result of which the matter could not be processed. Full stop. From a scrutiny of the materials on record, I find that the finance department was not a party in the writ petition, and therefore it is apparent that there was no direction upon the finance department to deal with the matter in a particular manner. Under the circumstances, since there is no dispute about the fact that the respondent has carried out his part in terms of the court order, it cannot be said that there is any willful disobedience of the directions passed by this court. First of, therefore, by granting liberty to the petitioner to avail appropriate remedy as may be permissible to him under the law against the finance department, this contempt case stands closed.
My lord, contempt application. My lord, the judgment was of 26/9/2019, page 11. Operative portion is at page 14. They have filed a writ appeal after 3-4 years, my lord, and the delay has been condoned till now. Writ appeal has not been admitted. But my lord, the issue was during the judgment delivered, the only thing was that to declare my result. I passed the written, then I passed the viva-voce. Declaration for declare the result. They could not declare the result. That was why I filed a contempt application. Thereafter, my lord, the stand taken before the honest single judge was that some of the candidates were left, were not sent. The names were not sent. So
Where is the order? Let us see the order.
page 14, operative portion. And it starts at page 11.
Result of viva-voce.
And what they have stated in their affidavit is this, my lord, viva-voce results are there, but the written examination results could not be declared because it is destroyed. And my lord, the persons, the agency which has conducted affidavit at page.
But in fact, against the judgment, we have prepared an appeal. Delay has been condoned by on 20th of January. Now the appeal is supposed to come. I would pray this may be taken with the appeal. That is one. Secondly, here is a case where against 2 posts, 4 persons they participated in the process, selection process, appeared in the written. Two of them were called for viva, and the result was directed to be declared. But what the authority have found that 347 applications, those were left out untouched in the office. Therefore, the authorities have taken a decision to go for a fresh. Ultimately, that has not been accepted by the Honorable Court and the order was passed. We have already preferred the appeal on merit, but I pray, this may be taken up. The appeal is pending.
We'll just adjourn it for 2 weeks. That's all, nothing more. In the
Lot.
meantime, if you can't get an order, then we'll see whether it's a case of. But then, Mr. Rajchandri, the state has preferred an appeal. We have to, Mr. P.K. Rajchandri, and counsel for the petitioners. Also have Mr. D. Nath, learned counsel appearing for the respondents, who has produced a copy of the order dated 21/2023, passed by the division bench of this court in IA bracket civil bracket close 3465/2022 to submit that writ appeal preferred to submit that the delay in preferring the writ appeal against the impugned judgment of the learned single judge has already been condoned, and the appeal is likely to be heard shortly. Therefore, this matter be adjourned for 2 weeks so as to enable the state to place its case before the division bench and obtain a favorable order if possible. Full stop. Taking note of the submission of Mr. D. Nath, this matter stands adjourned for 2 weeks. Mr. Rajchandri, you see, sometimes academics are evaporating slowly. But still, sometimes, whether it helps or not, it is good to remind ourselves the jurisdiction under 226 on Article 14 is on the ground of discrimination. When the authorities decide arbitrarily, discriminates, adopts differential standard, one against X, one against Y, then it becomes the constitutional duty of the writ court to step in and correct it. But if there is a good reason why the state feels that the result should not be declared, which could be that either there was some irregularity in the process, that would be a completely different matter. So keep that in mind.
Public interest.
What public interest? Yes, public interest.
Ultimately, your
Correct. So the writ court's job is not to give some benefit to someone here or there, but to protect them from arbitrary and discriminatory action of the state. If the state has a reason which is at least a permissible view.
Among 4 persons, 2 were from Jorhat, I think.
No.
Jorhat, and 2 were Jorhat persons were given the appointment. For us, we have been.
It is the same selection process.
Same selection.
Total 4 posts. Total 4 posts. 2 for Jorhat. Jorhat has been appointed. 2 for Kachar. For Kachar, 4 applications were received. They appeared in the written. 2 have cleared the written and appeared in the viva. They are the petitioners. So now 2 posts, 2 persons. So result to be declared. 347.
And for Jorhat, how many candidates were there?
No, Jorhat is a separate.
No, but what is it?
That information I don't have. 347 applications for Kachar. It is district wise. Application is to be received district wise. 347 applications, those were left unattended, not open in fact.
My lord, if your lordship has just called me, one thing I can ask, it is not to get the appointment. The order was to declare the results.
No.
The stand taken in their affidavit, the 6 years has passed by. Now the result sheets are destroyed. We cannot produce it before the court.
No.
So your lordship will take the consideration is declaration of results.
All right, so I am highlighting this because when the matter comes before the writ appellate court, both of you better get your act together and get a proper clarification. Yes.
The matter has already been instructed. The petitioner is got appointed.
I
am appearing on behalf of M. Bhagavati. Matter is completed.
You write, Mr. T. Sheikh, learned counsel for the petitioner, submits that in compliance of this court's order, the petitioner has already been appointed and therefore the order of the court has been complied with. Mr. M. Bhagavati, learned counsel for the respondent, has also confirmed the said position. In view of the above, this contempt case.
Item 44.
Malad, the contempt petition, Malad, order was not complied. Malad, can you see the last order, 14,922?
Which order has not been complied? Where is the order?
Malad, at page Malad, 18 is the Another 7 Malad. Start from page 17. And the operative portion is page Malad 21. In page 18, Malad, petitioner is number 4.
Yes.
Malad, he is entitled to Malad 12,86,886. Out of this amount, Malad, they have in the installment basis paid till now 8,50,320. The remaining amount is 4,36,566 is pending, Malad. And there are similarly situated matters, they have disposed of clearing all these dues, except me, Malad. And the last occasion, Malad, a check amounting of rupees 2 lakh was issued to me, that was not handed over, and it was expired. That is why, Malad, in the last order, court reflects any order at 14,922, Malad.
May I please your lordship? Lordship, the check was expired. He could not collect it from the office, lordship.
Give you a fresh check.
Yes,
Yes,
lordship,
that was
can he
direction.
fix it day after tomorrow, lordship will pay.
Sorry, that fresh check.
Yes, Malad, that was direction in the last occasion, Malad.
Lordship, the check was ready at the office, but he was not came to the office to collect the check, lordship. Therefore, it was expired. Kindly fix it day after tomorrow, lordship. We'll pay the check.
So, Malad, it is
What?
amount, Malad, all that we have no objection to go to the office, Malad. Remaining amount.
I had heard Mr. D.K. Das, learned counsel appearing.
The entire amount will be directed, Malad.
Also heard
Lordship,
Miss.
as per the instruction, they said that the amount is 2 lakhs.
Also heard Miss.
K. Bora.
K. Bora, learned counsel appearing with the respondent who submits that although a check was written in the name of the petitioner, yet since he did not collect the same from the office, the same had left. Full stop. Ms. Bora, however, submits that the petitioner will be handed over the check as and when he reaches the office. Full stop. In view of the above, this matter is directed to be posted again on 8/2/2023. The petitioner may report to the office of the respondent on 3rd February. 3rd February or 2nd February?
Any difference?
On 3rd February 2023 for collecting the check.
Item 46 and 47.
Lordship, in that case, respondent has filed their affidavit, lordship. So 2 weeks time may be granted to our.
Mr. H. Bajbura, learned counsel for the petitioner, prays for and is granted 2 weeks time to obtain instruction and file rejoinder in response to the affidavit filed by the respondents. Ms. R. Devi, learned CGC and.
Lordship, now here I am appearing in item 46, the contempt case, lordship.
Contempt case
Ms.
of
R. Devi.
Contempt case, lordship, already we have filed our affidavit and it has been complied.
So one is appearing in item 46, one is item 47.
47.
I am not 47 lordship.
So L. Devi, learned CGC 46 of Dibo, or Miss R. Devi, learned CGC in 47. Same order, separate, just change the name. List accordingly.
Contempt.
Item 48.
May I please, Lordship? Kindly adjourn the matter for the day, Lordship. My senior is out of station actually.
It's a contempt case. Who is your senior?
Mrs. Again.
My lord, may I please answer? My lord, matter may be taken up with another contempt case 437.
Heard Miss
A. Hussain.
A. Hussain, Land Counsel for the petitioner. Also
P.
heard Miss
P. Rabha.
P. Rabha appearing for the respondent who seeks adjournment on the ground that her senior who is appearing in this case is out of station. Miss Hussain also submits that this contempt case be listed along with
437/2021.
WBC or contempt case?
Contempt case.
Contempt case number 437
7.
of 2021. In view of the above, registry to list both the cases together after 10 days.
Item 49.
May it please, Mr. Lordship, the matter relates to non-payment of retirement benefit. This contempt petition has been filed for non-payment of order passed by this honorable court, my lordship.
My lord, I am appearing for the respondent. I filed the wakalat number 2 days
You are appearing for whom?
for the respondent. Ma'am. The respondent.
How many respondents are there?
Sole respondent, my lordship.
The respondent has appeared earlier.
No, my lord, earlier actually, standing counsel is there for the soil, department.
Soil conservation department.
So what is your instruction?
So, my lord, some time may be given.
Mr.
P.S. Raja, my lordship.
P.S.
Raja.
Mr. P.S. Raja, Learned Counsel is present on behalf of the petitioner. Mr.
A day.
A. Day. Learned Counsel submits that he has entered appearance in this case on behalf of the sole respondent only today by filing wakalatnama and therefore be given 2 weeks time, 3 weeks time to obtain instruction and file affidavit. Prayer allowed list this case again after 3 weeks.
My lordship, item number 50 and 51 also similarly situated. The same order may be passed. my lord.
You are appearing
Yes, ma'am.
50 and 51 same order.
I leave it.
Item 50. 52.
My lord, office note dated 25/1/2023 reveals service upon respondent of
And I'm appearing for respondent number 5. Notice 3 time may can be given to file affidavit in a reply.
Mr. J. Patwari, Learned Counsel is present for the petitioner. Mr.
B. Fukon for respondent number 5.
B. Fukan, Learned Counsel for the respondent number 5, prays for 3 weeks time to obtain instruction and
Affidavit file. Objection on affidavit filing for. Yes.
They want to file counter affidavit.
No, no. Objection on affidavit in reply. Affidavit objection.
objection and every, what is that?
Affidavit in opposition, Lordship.
You want to
affidavit
file
in
affidavit in opposition in the writ petition.
Petition.
What are you saying objection? So and so prays for and is granted 3 weeks time to obtain instruction and file counter affidavit. Mr.
M. Gogoi, Lordship.
N. Boro.
M. Gogoi,
M. Gogoi, Learned Counsel for the
1 to 4.
respondent numbers 1 to 4. What is your prayer?
They have filed their affidavit.
We have
I have
already
filed
filed.
it.
Submits that affidavit on behalf of his client has already been brought on record. In view of the prayer made by Learned Counsel for the respondent number 5, this matter will be listed again after 3 weeks as fixed item. Yes.
Obliged.
Item 53.
My lord, this is a case. My lord, in a nutshell, my lord, lordship will only have to see 2 documents. I am a petitioner is a my lord lady, postgraduate psychiatric nursing. She obtained and appointed as staff nurse at my lord LGB Regional Institute Mental Health at Tezpur, then regularized. White page 20. In 2006, my lord, 6 pay commission recommendation as per that new revised pay fixation was done by respondent which your lordship will find at page 31. Page 31 is the pay commission revision. Lordship may have a look at this. That is way back in 2013. All the nurses and matrons in partial motor disorder staff who have joined this institute prior to 2006. I joined much prior. So event is as specified this. Now, as per the 6th pay commission recommendation, the approval was given and this was granted. And we have been paid, my lord. I have been paid. This has become part of my service condition. And then, my lord, suddenly it is under central government. This letter comes at page 34. This is by the regional. Page 34 letter says 21. This is in the year 21. 2016, we have been given. Hereby for all existing nursing personnel who joined prior to that, CAG audit has raised objection that pay fixation in respect was done erroneously. Then, therefore, it says it has been decided that a lump sum amount of 20,000 rupees only per month shall be recovered from the salary of each nursing personnel. Without notice, this was given to us unilateral pay cut. It was a sort of a penalty, my lord, imposed. Couldn't have done, my lord. Then, thereafter, another order at page 38 also, lordship will see page 39. This is in 2022. As observed by CAG audit, a provisional list so-and-so, address here in the provisional list, my name is there. Again, a lump sum of 5,000 PM will be deducted from the monthly salary. So there was an interim order, but already certain amounts were recovered. 20,000 plus 5,000 is 25,000 for a nurse, my lord. It is a pretty monthly amount of salaries. Now, what happened? Some other nurses also challenged this case. And Lanet single judge, somehow this case was not taken with those cases. This still remains independently. And my lord, the learned judge, my lord, single judge, my lord, disposed of the matter by setting aside both the orders. Lordship may have a look. It discusses about, my lord, the learned single judge discusses about, my lord, number of Supreme Court judgment, which says that after several years of paying higher pay scale, you cannot do, the employer cannot do it. Paragraph page internal page 10, my lord. And internal page 9 also there is one decision. Recovery excessive paid to the petitioner due to a wrong fixation of pay cannot be permitted. These are all Supreme Court judgments. It is a settled law. Of course, in these cases, this second order was not impugned, which I annexed 5,000. And then, my lord, a number of cases, the cases are very clear that if for years you pay, subsequently you cannot say that due to erroneous, my lord, fixation, you pay back down. Then, my lord, paragraph 12. In view of the reason stated, this court is of the view that there cannot be any recovery of excess payment due to the wrong fixation of pay made by respondent 16 years ago. Accordingly, the impugned order, this is pay cut order of 20,000. In my case, there will be another order, the second order of another 5,000, my lord. Otherwise, my lord, everything is same. Now, I am being told, my lord, my learned friend appearing for that hospital authority, that these petitioners, this judgment, they have filed a review petition. And my lord, review petition, my lord, and an expert stay was granted against those petitions. I am not there. Now, it is open for your lordship to pass an order in the light of this. This your lordship will, then they will have to file a review before your lordship. And then notices. Somehow there were 7-8 petitions in that series of petitions filed slightly earlier, around 3 months. At that time, the second 5,000 cut order was not there. I challenged both the cut orders. That is the distinction. Now, on your lordship may pass a judgment in this case. And if they decide, they file a review or they go on appeal, it will be their prerogative. But the Supreme Court decisions are very clear, my lord. That is the position, my lord, I am saying. Just now I am being told that these cases, they are the review. And notice was issued because the nurses didn't appear, those petitioners didn't appear, expert. That is the position.
No, I was about to ask him whether there is any appeal filed against this order. But anyway, yes, what do you have to say?
A good number of cases are pending here in this before this honorable court. 8 cases are disposed of by this honorable court through this judgment, my lord. That this judgment is passed in the light of Rafiq Masi case. That holding that they are belongs to category C.
Rafiq Masi is for recovery against retired officials, retired government servants.
They have
Cited other cases also.
my lord, they belongs to category B. On the other hand, in another case, my lord, after receiving the benefit, they have given the undertaking to the authority. And if High Court of Punjab and Haryana and which in that case, that the Honorable Supreme Court said that employee is bound by the undertaking. Because of that.
Mr. Barbara,
Sambabu's case, my lord, Sambabu's case 94-2, it said the apex court was of the view that recovery after several years of paying higher pay scale would not be just and proper as the same was not due to the fault of the employee.
you may be right in that, but the point is, unless that aspect of the matter is settled, even if there is an order passed or not passed, the relief is not forthcoming. So let it be tagged up together or deferred till the reviews are disposed of.
No, my lord, I don't know that there will be a review of whatever lordship will take.
I will
this
not
matter.
pass an order since they have.
Lordship may take this matter as it is, my lord, because I have one additional impugn order, which was not there in the other cases.
My lord, I have to pay.
Not
I have
today,
to
not
file
today,
a
not
affidavit
today.
in opposition in this case, my lord.
It's all right. It's all right.
I have to.
Lordship will take note of the other judgment also, definitely. Why not?
Mr. Resi Barbara, Learned Senate Counsel appearing for the petitioner submits that the case of the petitioner's hearing are covered by the judgment and order dated 13/9/2022 passed by the learned single judge in WPC number 258/2012. And therefore, the matter can be disposed of accordingly. First up, Mr. A. Datta, A.K. Datta, learned counsel for the respondents, on the other hand, submits that a review has been sought against the order dated 13/9/2022, which is pending disposal before this court, and therefore he be granted some time to file affidavit bringing the relevant facts on record of this case. How much time you want?
And then Lordship may also observe about the page 39 subsequent order, which is not there in the other cases. I am challenging.
Mr. Barbara, however, submits that the subsequent order dated 19/1/2022 was not the subject matter of challenge in
Yeah, that
WPC
is-
number 258 of
Yes.
2022.
They came
Therefore,
before that.
the claim of the petitioners in this proceeding would have to stand on its own merit, and therefore, and be accordingly decided by this court. Full stop. Be that as it may, since the request seeking 3 weeks' time has been made to file affidavit, and the
Yeah.
same stands
Let it
allowed.
be sometime in March, my lord.
Yes.
Has to go.
Let this matter be listed again in the first week of March
That
2020.
may be given, my lord, for admission.
Second week of March 2023 for admission. In the meantime, the respondents to bring their stand on record in the form of affidavit.
And meanwhile, my lord, the interim order shall continue. Other takers, I am protected.
Interim order passed earlier to continue.
Lordship. Haji copy.
The last week.
May it please your lordship. This is a contempt application where we were retrenched without following the law. We were bank employees. Initially, we were appointed temporarily.
It will
then
take some,
regularized.
it will take some time.
Yes, lordship, because there
Say they delete all the names, who are not necessary parties, except the employer who can appoint. So the prayer is, my lord, only to, my lord, retain the chief executive director of Escort Bank and delete all other names. So that order may be passed, my lord.
Lordship, what had happened is the order of the writ court was to the board of directors to reinstate us and pay back our old salaries, So in view of that, we had filed the contempt petition, impleading all the contemners who were there in the writ proceedings. Thereafter, they had filed an appeal was dismissed. And then another issue that cropped up. After that, there was an order by your lordship saying that
It will be fine.
after that, there was another order by your lordship that implead the new incumbents. We had impleaded 5 respondents. Thereafter, new incumbents had come, others were transferred. And so we had also impleaded those new incumbents. After that, Honorable Justice Gujar Bora had passed the order that we have to implead only the appointing authority. But I may say appointing authority is the board of directors. But we placed appointment orders before learned Justice Gujar Bora, and a learned judge saw that it was the chief executive director who had signed the appointment order.
Where is the order? Which page is the order in the IA?
Lordship.
229, my lord. Last page, my lord, of
IA.
contempt case 468. I think my number is. Dipen Goswami's case, my lord, is
yes.
page 229.
IA number, the IA number.
Contempt case 468, my lord. Dipen Goswami.
In that page number?
229, last page, my lord. This is the order pursuant to which this IA has been filed, my lord. The petitioners to implead.
229. There is no order of 229.
In our IA, it is page number 116. In our IA, that has come up before your lordship, the first IA. The first file, yes. 116.
The wrong presentation given to me, my lord.
Oh, that was cut, see, that was cut in 116, lordship will see the order, the petitioner to implead the actual authority who is required to reinstate them and file appropriate application for deleting the other respondents who have been wrongly impleaded as contemners. But I may say the chief.
So who said they are wrongly pleaded? Whose case is this?
It was nobody's case. Justice Gujar Bora had seen it and he ordered that.
Accordingly, my lord, this IA has been filed.
In view of that order.
She will see the prayer, that prayer has been made, my lord.
In view of that order, we had to file this IA. And it was deliberated during the course of argument that it was the chief executive authority who had signed the appointment order. And so it was said.
Page 54. Page 54 is the prayer portion, my lord.
No, but this is a contempt case.
Lordship.
Notice was issued to the opposite parties.
Yes.
They have appeared.
Or
Yes.
they notices, sir, all of them did not appear. Respondent number 5 and few respondents appeared. And one of them had filed the affidavit. But then it was the
But
nobody.
then it will be is tomorrow if it becomes necessary to ask any of them to show cause, then what do you do?
And that is also our prayer. If it is required, we will implement them again.
Oh.
Because otherwise we would have no option. But learned judge ordered us, so we did it.
May I submit, lordship? In this case, lordship, recently, lordship, the chief executive director, he was already retired, lordship. Another person, B.K. Agarwal, will join newly. They have to implement this present incumbent also, lordship. And the lordship board is already been dissolved, lordship. Now, one person appointed by the cooperative department or manage this affair, lordship.
No, that's all right. The petitioner in their own petitioners in their wisdom on legal advice have impleaded some respondents alleging that they are the ones who have violated the court order. Correct?
Yes.
Either they have to come and say that we have nothing to do with the court order, or there has to be some finding that these incumbents have got nothing to do with the implementation of the court order.
There's nothing of
That's not there.
That's not.
Now, if there is an order that delete their name, tomorrow, how will the contempt case proceed?
This is what
The contemners may or may not be guilty, they may or may not be punished. But then what do you do tomorrow? Again, file another application for impleadment.
and this is what even we have stated that in our petition.
I mean 55, 56, Lordship. I am also in a dilemma, Lordship, what to do.
They have not filed, but
I
I
have not
have,
yet filed, Lordship. I am just thinking what to do. Lordship. Because they are necessary parties, Lordship, according to us. Lordship.
But Lordship, here is
because they are the members of board of directors. And Lordship, we may see the order of the writ court at page number 91 of the contempt petition. There the direction was to the respondents who are the board of directors. In that case,
Page
Lordship,
number 91.
91 of the contempt petition. Contempt petition number
You create
468.
problem in this matter, Mr. Talukdar. The learned judges passed that order, but then there is no indication why they should be.
Yes, there is no
Yes.
indication in the order. The honorable court said that the appointment can be made by the employer. And the board of directors or the executive director, whoever he may be, he can appoint. But the other registrars, secretaries, they have nothing to do.
No, they are
And
the
they have been
members.
implemented, madam. They cannot appoint, madam. They
No,
are
no,
not the appointed authority.
that's not the point.
My-
Point is, if the observation was that they are not responsible for implementation of court order.
Yes,
This is a contempt case, right?
correct.
So only issue is whether there is a willful violation of the court order,
Yes.
not what is their functional sphere.
Yes.
If the court would have discharged them that they have nothing to do with the contempt case,
But that would have been different.
that would have been different.
Madam, understand.
In that case, it would be open for them to either accept it or assail it.
Madam,
But
understand.
now they are also in a dilemma because
Yeah.
according to them, they want them, but they are now compelled to
Yes.
Yes,
let
this
them
is
off
what
the.
has
That
happened.
perhaps cannot be the way our judicial proceeding
Yes.
needs to proceed, because it is for them to decide whom they want to be
Mm.
parties. And they petitioners will, of course, the court may or may not agree.
Madam.
That is another reason. But in that case, there should be some observation that these people have nothing to do with implementation of
Right.
court order.
But since there is an order, they either, if they disagree, this order is required to be challenged, or these cases need to be go to the honorable single judge, passing this order. I think, because this order is not under challenge, by honorable justice.
This order we have not challenged
This order remains on record, madam.
because we have filed so many cases. Earlier also they were retrenched. We filed contempt. They went to Supreme Court. And then again we were retrenched by following a wrong law. So we filed writ. Writ Lordship 91, Lordship will see, page number 91, we were allowed.
Who are these? They are Ascot Bank employees.
Ascot Bank.
Ascot Bank has gone to the
Yes.
thin air,
I think they are restructuring.
gone long time back,
Long time back.
more
But
than a
it's
decade back.
functioning, but
No.
it's
Just
functioning.
the branches are existing, my lord, no function. no?
that branch also sealed by this honorable court. Lordship,
branches-
in repetition order, Lordship. 34 branches. Honorable Justice Bujal Borua,
I know.
order, Lordship.
Oh, and they
There is
have
order,
ready
Lordship.
for,
All branches are sealed. Now no activity, nothing, Lordship. Functioning stop, Lordship. Through a writ petition 404. Now, Lordship, the cooperation department is important part in this case, Lordship, contempt petition. Because cooperative department is the 84% shareholder, Lordship, in this society, Lordship.
that is why we have made
Otherwise,
them
Lordship,
parties.
only chief executive director, nothing can do, Lordship, in this matter, Lordship. That argument I have already submitted before this, that bench also, Lordship.
But the learned judge says their names to be deleted.
Yes, Lordship. Yes, Lordship.
Their name should be deleted. We placed
Without
the
department
appointment
action,
orders
Lordship,
and there
it
it
is not
is
possible.
sent. There it is, Lordship had seen that chief executive director who had signed it. And so that order was passed and we were directed.
Chief executive director.
So
also-
then you have to seek recall of this order.
That is an option, but we thought we will again let the matter go on.
No, a legal proceeding can't go on like this. See, there has to be some sobriety, sanctity in a
Yes.
proceeding, is it not?
Yes.
How can you keep doing that? Today you
Ah.
delete, tomorrow you again, what? This is not some kind of a joke.
Yes, that is I
How
agree,
can
yes.
it be?
This has been pending since long, 2019. so-
All right, but due to propriety's sake, it will not be proper for me to comment anything else.
Mm.
Seven, except acknowledging that there could be an issue which
Mm.
might have escaped the notice of the learned judge.
Mm.
But then
Then we will challenge that order.
That is the
You have
only.
to take remedial measures, what to do. Because it will be problematic for your clients.
Yes.
If you delete their names, you can't again implement them. There will be other legal complications. What about your case also same order has been passed?
But since they are necessary, nothing. I was thinking of-
Take down hard Miss S. Jahan, learned counsel appearing for the petitioner in IA number 3588/2022 submits that this IA has been filed in terms of the order dated 9/11/2022 passed by the learned single judge in WPC in contempt case number 468/2018 for deleting the name of some of the respondents. Ms. Jahan, however, submits that on a deeper scrutiny of the materials and record, the petitioners are of the view that those persons are necessary for a just decision of the controversy involved in this proceeding. And if their names are deleted at this stage, it would cause serious prejudice to the interest of the petitioners. Full stop. Mr. S.K. Talukdar, learned counsel, learned standing counsel corporation department submits that although he is not disputing the contention of the petitioner's counsel, yet unless the order dated 9/11/2022 is not recalled, the recourse adopted is not recalled. The petitioners would not have any option but to file this application. First of Mr. A.U. Ahmed, you are for?
Respondent number 5.
A.U. Ahmed.
Earlier, executive director.
Mr. A.U. Ahmed, learned counsel appearing for the respondent number 5, who was the erstwhile chief executive officer of the bank, submits that 85% of the shares in the Ascot Bank, 84% of the shares, stakes, not shares, stakes in the Ascot Bank is held by the Corporation Department, Assam, and therefore the Register of Cooperative Society is a necessary party to this proceeding. First step. Having heard the submission of learned counsel for both the sides, this court is of the opinion that the issue raised would require further deliberation. Full stop. As such, this IA is kept pending and shall be considered at the time of final hearing of the contempt case number 468/2018. In the meantime, it will be open for the petitioners to seek review of the order dated 9/11/2022 if so advised. All right.
Obliged. Highly obliged.
Other cases similar. ma'am.
Other cases,
Three
item
cases.
54, 57 also same.
Same matter.
But there is no IA.
No, they have not filed.
56 I have not.
Connected matters, they are tag matters. This order will do, my lord.
Lordship, they have to implement present incumbent also, Lordship. B.K. Agarwal.
That is okay.
Obliged, ma'am.
Mr. M. Bhagavati, learned counsel for the petitioner, submits that necessary steps in terms of the order dated Azir order in the IA will be taken on behalf of his clients as well, including steps for filing application for implement of opposite parties who are responsible for implementation of the court order. In view of the above, let this matter be listed along with to IL over Devodevo. Same thing with Ms. J. Paul. You are in which item?
54. 57.
57.
57.
57.
57 and Ms. J. Paul, declares same. Same. Is your voice gone because of the order? When it judges made you voiceless or? Huh? Don't lose your voice.
Yes.
So that's it. We'll
My-
see.
my lord.
You are there in these cases.
3 ma'am.
56 and 57. Your name, please. Ms. S. Musari, learned counsel is present on behalf of respondent number 3. 56 and 57, Dutta Divo.
Not.
All right.
Obliged,
Obliged.
highly obliged.
No, you see, sometimes
Hmm.
orders are passed, at times the court is also pressed with time.
Yeah.
So maybe the learned judge did not look at it from that perspective.
Correct.
So you have to point it out by filing a petition, which is the proper recourse.
No, we will do it.
After that, if it doesn't work out, then you have to avail remedies.
Maybe
if you
there are other options. Yes.
Right.
Lodge. All right.
Finding matter, I can.
There, please, my lord. My lord, here the facts are like this. He was, my lord, given a show cause. That was way back in 2017. 18, the report came. But the report was kept pending. In 21, a penalty was issued, my lord. Withholding of 1 increment. Now, because he was under suspension, from 16 onwards, 17 onwards, his increments were not being given. After this order, the AG, my lord, took up the matter. In 2018, in 2021, he took up the matter. And my lord, the increment of 2017 was withheld. And in 2018, both the increments were given because it was not with cumulative effect. Both the increments were given back. He intimated that to the department. Now the selection took place, my lord, after 7/7/21. 7/7/21 is my representation. In this election, my lord, they took a stand. The selection committee took a stand. As the penalty was issued on, my lord, 10/2/21, this will come to an end only in 22. The currency will come to an end in 22. Accordingly, we will not consider it. Accordingly, my case was not considered. My junior was promoted, my lord, on 25/10/2021. This is my case, my lord. So the penalty that was there, it was withholding of 1 increment. If my lord can have that penalty at page 33, my lord.
So that means you will now ask for a review DPC.
Review DPC.
Where is the prayer?
Review. My lord, I have only said, my lord, pair number 2, my lord, page 23. Issue a writ in the nature of manner, direct the respondent authorities to promote the petitioner to the post of superintending engineer agriculture with effect from the date of promotion of his junior by applying the next below rule with all consequential benefits of pay, seniority, etc. Rectify the impugned notification for promotion to the so and so and include the name of the petitioner, while an order, direction, notification, courier, and or pass such further order as your lordship deems fit and proper.
Mr. Nair, this petition was definitely not settled by you.
My lord,
It was drafted by someone who has no idea.
My lord, I escaped my notice. But my lord, when I asked for a prayer of next below rule, when that is there, my lord, I'll pray, my lord will use my lord's power and direct for a review DPC.
No, but we'll have to grant her time to obtain instruction.
But they have obtained, they filed affidavit also, my lord.
Review DPC only possible because lordship, there is a letter from the Joint Secretary Assam Legislative Assembly to all the chief secretaries, lordship. After careful examination, the committee was of the opinion that clause 3 and 4 of the aforesaid OM shall be reviewed and modified by the concerned department, and all promotion process, irrespective of all categories, should be kept in abeyance until the review modification of the said OM completed to avoid further contempt of court and deprivation of the candidate belonging to the reserved category.
Ms. Bora, 1 minute, 1 minute.
Lordship.
Do you know what is the review DPC? Do you know it? Be honest.
Your lordship,
Do you know?
the DPC will,
What is the meaning of this expression review DPC in the context of service law jurisprudence? Do you know that?
the departmental promotion committee.
We don't know. Do you know or not? That's what I'm asking you. Yes or no? Yes or no?
No, lordship, not that
No.
clearly, lordship.
All right. So if you don't know, then you won't be able to respond to the court's query. The first is the only remedy in petitioner's case is if he succeeds. Let's assume he succeeds, the court can direct a review DPC because there is no other method to go back in time except a review DPC. He has not paid for it. You don't know what is the meaning of it. What does the court do? Can we pass an order today?
No, lordship.
You tell what is to be done, both of you. You consult and tell me the order to
My
pass.
lord, the question is first, my lord will have to be satisfied that I was entitled to be considered on that day. If my lord is satisfied to that effect, my lord, that reservation notification has
No,
come.
but
my
the
lord.
problem is she is confusing a review of a notification with the
Lordship, may
expression.
kindly peruse
Reserve,
my instruction,
reserve.
Lordship,
My lord,
may
that
kindly
reserve
peruse.
lord had dealt with that matter after the fresh notification had come. There was the case filed. It came up before your lordship, my lord. There was the Dasar had done it, my lord. That this was prior to that. But here, these things will not come because there is no question of reservation involved here. If my lord is satisfied that the expression that they have used,
Last 2 pages, Lordship, in last 2 pages, Lordship, there is a letter of 9th August.
it was AIIMS.
No, but that is SC/ST.
Yes, yes, that has been taken care of.
Is the petitioner a member of the
No,
SC/ST?
no.
Then how is it relevant?
All promotion schedule, that's why they, my instruction is that, Lordship, that's why they are not being able to constitute the review DPC, Lordship.
No,
The
that
next
notification
DPC
has
will
come.
be considered
17th or 18th January,
Promotion.
the notification has.
Do you have any senior colleague who is assisting you or who you are assisting in this matter?
I'm the one, Lordship, I'm the
You are the one.
Lordship.
Then you make your submission. We don't think you understand what is the meaning of review DPC. Review DPC doesn't happen on your consent. It is a matter of direction from the court.
Lordship, may kindly grant me sometime on the next date, I'll appraise your Lordship.
But Mr. UK Nair, Leonard Senior Counsel, assisted by Ms. So-and-so, Learned Counsel appearing for the petitioner. By referring to the materials available on record, Mr. Nair submits that since there was no proceeding pending against the petitioner on the date on which his juniors were promoted, hence by resorting to the within courts next below rule, this court may issue a direction to the respondents to hold a within courts review DPC so as to consider the case of the petitioner with effect from the date on which his juniors are promoted. First term. Ms. R. Bora, Learned Counsel appearing for the Agriculture Department submits that since there is no prayer in the writ petition for constitution of a review DPC, hence she be granted a week's time to obtain specific instruction and respond to the prayer made by this court. On the request of Ms. Bora, this writ petition is directed to be listed again on 9th of February 2023 as a fixed item, so as to enable her to obtain instruction. You please understand what is his prayer and get instruction, right? If there was no reason why he was not considered on that day, then you will have to constitute a review DPC, consider his case as it stood on that day.
Yes, sir.
And then take a decision. That is called review DPC. Yes. We'll see what happens, Mr. Nair. You have some judgments, come with those.
Let me get those. The only anxiety is my lord man is retiring in March 30th.
No, but what to do?
I'll be there.
These painful stories are.
No. If I retire also, my lord can give me those benefits. There is no problem. Much obliged.
Yes, next matter, please. Elias Lower. What about part 2, hearing? Call up matters, I'll dismiss.
Item 3.
Give me the file, I close some cases.
Item 3.
All right. Next date we'll call and dismiss.